She's very much, or this one, outlined relevant laws to support his inherent authority. I don't think so. I think he had an abuse of authority, but okay. Judge Glanville maintained that no one gained a tactical advantage as a result of the ex parte nature of the meeting. Yeah, okay. Judge Glanville also questioned defendant's right to be present at the ex parte meeting because the issue under discussion was between state and a witness who was represented by counsel. He questioned who? Judge Glanville also questioned defendant's right, meaning he disagreed that they had a right to be counsel. I mean, like, why are you being so artful? He denied defendant's right to be present. He didn't question anybody. He didn't go and ask judges, how do you feel about this? And furthermore, the meeting because the issue was discussion was between the state and a witness. No. It wasn't. It wasn't. The discussion was between the judge, the state, a sworn witness who was represented by counsel. This is the witness is on the stand. He's on the stand. After making this record, Judge Glanville announced that the show cause hearing was canceled and that the recusal motions filed by Kendrick, Williams, and Bumpus were being referred for consideration by another judge in accordance with the Uniform Superior Court Rule 25.1 through 25.7. Sounds just like the same rules that Weinstein was absolutely going hopping up and down about, I think on June 14th, when he said, you can't make that ruling. You have to follow 25.1 to 25.7. Sounds like that very same rule that he all of a sudden, Judge Glanville, found out. And I guess because you want to keep it under 10 pages or you want to be, poignant, but this looks like you're trying to wipe the hands of Judge Glanville because there were so many instances where various attorneys, Adams, Weinstein, Steele, were all informing him that his actions were out of sorts. And you know who wasn't? Was the prosecution. And they have an ethical responsibility. It's not about the win. The win is one thing, but the integrity of the court has to be maintained. All officers of the court are required to maintain the integrity of the court, regardless if they're on different sides of the bench. So just as Steele, Adams, and Weinstein were hyping and hopping and hooping and hollering about, motions to recuse and issues and ex parte meetings without them and Brady violations and potentials, and they need to understand what's going on and why. And all he wanted to know was who was the parrot and all that. That's not none of your business. And Miss Love's rocking and a rolling and a hipping and a hopping and a whooping. All that was wrong on the prosecution's part. They know better. Hello, Lyric Armstrong, your real estate agent and advocate. Listen, I am not ready. I'm not ready, but we have breaking news in the YSL case. So I just said, forget it. I can't find my microphone. The light's not right, but baby, this right here, I didn't see it completely coming, to be honest with you, though there's a little bit of telltale signs. So we're going to get right on into it. If you don't know RICO case YSL, go check out the playlist. We've kind of jumped in at the very last minute here just because of the spiciness of the court encounter with Brian Steele and Judge Glanville. Well, we have breaking news, breaking news. Things have happened day after day after day after day to where, if you have life and court and things to do on your own, you have been left behind. But guess what? You're not alone. I'm here to help catch you up while I catch myself up all at the same time. So let's get into these motions and see what's happening. What's happening, Captain? So how do we get to this point? There's so many ways this road led us to this aggravating place. I've said it before. It's one of those things where either You know, someone is acting like a gang, or someone is acting like a mob. And for me, it was like a judicial mob. Now, in some of the reviews, you, like I said, if you look over some of my other recordings for YSL, I could see Judge Glanville have this endearing appreciation for the prosecution in some way. Whether there's a personal connect or not, I cannot anywhere near to proclaim, but just the visual would be assistance with the prosecution in objections, or helping to make arguments, and maybe not much of it in front of the jury, but nonetheless, even some things in front of the jury. Went back and found out that there's a time that in front of the jury, ADA Love, or DA Love, gets up and identifies that Mr. Steele is somehow unprofessional and unprepared, and she was incorrect in her statement. But the judge sided with her originally and did so vocally in front of the client and the jury. And that is not, it's not good. It's not good. You, as a judge, you want to look impartial. For one, you don't want to take one side's, how do you say, one side's overall perspective or their conclusion of the facts without having understood the other side's determinative perspective or understanding. So that when you as the judge are making a balls and strikes call, you're doing so with both sides of consideration. But I've seen it, you've seen it. Judge Glanville just would seemingly have an automatic acquiesce to the prosecution. But then even after Mr. Steele is like, no, I'm professional, I'm ready, she's a lie, here it is, here's the proof, the judge kind of shook it off like, oh, you know, mistakes happen, versus, oh, well, excuse me, we apologize, the court apologizes. So that can be problematic. That was covered, I think one of the law tubers covered more in detail about that. But we are here today. It is July 15th. I'm tired, I'm exhausted, but we got to figure out what's going on. So we looked at the ex-parte transcript word for word. And I told you as I was reading it for the first time with you publicly, I felt like the transcript was missing context. There was obviously communications not communicated in the transcript. And Judge Glanville gave some notation at one point that he was going to let his court reporter clean it up and send it out. But that's a weird thing to do because, like I said, Attorney Adams was like, "Hey, just run me the rough." And I'm like, "Look, I feel you. Just run me the rough. I want all the mistakes. I don't care about a cleaned up version because this is dirty in and of itself. So just run the rough." And I talked to you about what a rough transcript is. It's basically before the court reporter puts it in online paper and goes over it to ensure what was audible is reflected and spellings are corrected, especially like name spellings, because sometimes the names get misspelled when you're doing it automatically. So you get a rough draft, and a couple maybe a week or so later, you get the final version, which is the certified copy. The certified copy is to say, I as the court reporter certify that this copy is the correct and true copy. It has been reviewed. So Attorney Adams was like, yo, I want the hearing, the audio hearing recording that you say exists, and I want the transcript, and I don't want to wait for you guys to clean it up. Just send me the whole thing because this sounds fishy. I was with him. Run me the rough. Because when we went through the ex-parte transcripts, the judge says, oh, we didn't need to clean it up because one of his things was he wanted to take out what was proprietary or potentially client privilege. So he was like, oh, we don't need to clean it up. We're good. No need for that. So consequently, here's the whole thing. And I'm reading it and I'm going, this does not sound like the whole thing, because words were being said with a lot of pretense to, well, like, what was one of the words? Yet. Like, you keep saying something, but we haven't gotten there yet. You keep saying this, but we haven't gotten there yet. So, we keep talking about what's not yet happened, but we don't need to. And it was something about the word yet. I'm like, this is the first time it's come up in the transcript. What are you talking about? There is no keep saying anything yet. So that was very telling that the transcript was incomplete. Then there's there's also moments in time in the transcript where the conversation is on one subject matter, and all of a sudden you're in this different subject matter without any real transition. So that made it look incomplete as well. So there's a couple of highlights if you care to go back. We're going to go as fast as possible because we want to get into what is going on right now today. So 5 days ago, and I was going to cover this. I was going to cover this particular motion with Ben Steele, Brian Steele, who I love calling Ben, and he's not Ben. His name is Brian, Brian Steele, Mr. Steele, the actual attorney for Mr. Jeffrey Williams, who is also known as Young Thug. And I think there are some other nicknames, but we're just going to keep to the ones I know. And truthfully, I really believe that it's disrespectful to not call him Mr. Williams or Jeffrey Williams or, something close to that. So I'm going to try to stay there, but you know who we're talking about. This is a Superior Court Fullerton County filing. And format-wise, it gives me like appeals court vibes because there's no line paper. I mean, there's no lines across the left-hand side, but this is still Superior Court. So just know that every court is different. They do things differently. And I may because it's criminal court too, that it looks like this. As you know, I deal with civil court, not necessarily criminal. Anyway, the indictment number is stated. This is relative to Judge Glanville. I will assign to Judge Glanville. This motion is the title here. Motion for a fair trial, as well as motion for a list of dates and persons who participated in any ex parte communications with the court, and the topic of the same motion for mistrial based upon judicial and prosecutorial misconduct, and thus bar retrial. Oh, okay. There was like one where Mr. Steele had put in footnotes in the title of his motion to recuse, because guess what? This is not the only motion to recuse. This is like motion 3025. Okay, every defendant has a motion somewhere, and Mr. Steele has about 2,000 motions for recusal, and then I think Mr. Weinstein probably has the remainder. Like everybody has motions to recuse. There's a gazillion, but anyway. The motion to recuse was specifically noted for not just Judge Glanville, but also for the prosecution. And I don't know how far, we'll see what the order does to that. But when we were reading the ex parte, one of the things that gave me a concern that Judge Glanville will not recuse was because of the supposed emergency. The emergency was inserted by the prosecution, stating that the original attorney for Copeland, which was Melnick, stated that by some realm that the prosecution was going to be putting Copeland in danger by making him take the stand. So they called an emergency ex parte hearing with Judge Glanville and all those other 13 people, whoever was coming and going. And it was very, as I say, the atmosphere was intimidating in my opinion, because you had a lot of police officers or detectives and deputies, as well as the prosecution, and you just didn't have any representation from the defense. And then you also have the judge, you're in the judge's chamber. It's a much different effect than just being in open court. And being in the being on the witness stand in that cubicle has a very different viewpoint. Being at the table versus being at the stand, versus being a juror, versus being a spectator in the pool, in the general public seating. The anxiety levels or the perception that you have varies completely. And this is personalized, but there is a difference, an inherent difference, just by being in different locations within the courtroom. And then on top of that, now you're in the chambers. So I took issue with that too. But anyway, let's get into what the motion says. Yeah, Brian Steele, when he mollywopped, when he was tic-tacking with Judge Glanville in open court, that was a great visual. But in the motions for recuse, he went in. And it was like he was legally cursing him out. He was legally spitting in his face. And I say legally because he was using legalese to do so. He wasn't, he was disrespectful to this sense, like he was like saying Judge Glanville versus the Honorable Judge Glanville. Judge Glanville versus saying Chief Judge Glanville. Things of that nature are, you may say, oh, he's keeping his word count down so he can get his motion in. No, it was very real, because when it came to recusing Judge Krause, because he did a motion to recuse Judge Krause, she was the Honorable Judge Krause. And as soon as he said that, then he would say something Judge Glanville, and it would be right after. And then Weinstein, the attorney for Kendrick, he would say Honorable Mr. Weinstein. Like, everybody else was honorable except for ADA Love, ADA Hilton, and Judge Glanville. They were dishonorable, and he said so in, without mentioning any words relative to what he stated. So here comes a snapshot of what he says. Here comes now Jeffrey Williams, once again, Young Thug, through his undersigned counsel, once again, Brian Steele, and hereby files the motion for fair trial, as we have already noted from its title. Now, bar for retrial, meaning that it's barred from going back up. So it's like with prejudice, which we got out of, what case is that? Oh my gosh, Alec Baldwin. I mean, the legal moment in time these days is so historic. I mean, I don't know that a lot of, whether it's going to be Massachusetts versus Karen Reed, because we now have a motion on that. We had a declared mistrial. Now we're like, wait a minute, let's declare a mistrial on only one count, because the other counts of this, that's a third. So now we have to see what happens there. But between Alec Baldwin's case, which I actually don't even remember what state that was. Was that Arizona or whatever state it was? But no, New Mexico, right? New Mexico versus Alec Baldwin, and now Georgia versus Jeffrey Williams. Oh my goodness. I don't know what law professors are going to be teaching relative to these particular cases, but these cases have definitely spoken to the community, and they have taught us. So we have learned, we are learning, and we have learned. And so thank you once again for making these cases public. There may be massive embarrassment to Judge Glanville or some other judges in Michigan and so forth, and just because of the missteps being so publicized, and the bobbleheads of YouTube, the little lady in the square having the ability to pass judgment on hindsight. But I will say that it is it's needed for the public. We need to know. And so, though it may not be the most comfortable place to be in, thank you for making it public and keeping it on YouTube as long as you have. Hope you guys keep doing that. Now, so this is what this motion is talking about. Mr. Williams says, number one, he's innocent of all crimes in the above referenced indictment. That's number one for every last motion ever. Like, if your attorney is not putting innocent in that's your plea. Like, if you did not plead guilty, if you did not plead guilty by reason of insanity, then your attorney is putting number one, Mr. Williams innocent. They're putting you down. You're innocent of all the crimes. That is always number one paragraph. Number two, from its inception, this trial has been constitutionally unfair, as this court has failed to be impartial to defendant Williams and or his counsel, and has been objectively biased in favor of the prosecution. Some examples of the same include, but are not limited to, the below. Prior to opening statements, this court ordered all parties to share with each other any demonstrative aids. This is okay. This is important. So this was an order to share any demonstratives. As we know, demonstratives are not evidence. So demonstratives don't go back with the jury when they get the case in deliberation, but demonstratives are demonstrating a thought process, a pattern to help the jurors to determine the theory that is being presented to them by the prosecution and or the defense, right? So both sides have a reasonable ability to present demonstratives. And what is being stated at this point during pretrial motions before opening arguments, both sides were ordered to share their demonstrative aids that they seek to display to the jury during their opening statements that were going to begin November 27th of 2023. Yes, almost a whole dang on year ago for opening statements. Do you know how much pretrial? There's like another year of pretrial work here. Okay, hold on 1 second. Hold on. Sorry, I had to get my water bottle. My throat. I ain't been speaking all day. meetings all day. So anyway, so we have a 1 year ago that you did trial, and then before that, pre-trial, a year or year and a half. Like trial, this is a very long trial. And I believe we're 100 days of trial days. So shout out to the jury. Like, love that jury. They have, whew, they have committed. They have committed a great deal of time and effort. I hope they get transportation. Probably not, but I would hope so. Because 90 days to be driving to some courthouse, or I'm sorry, 100 days to drive to courthouse, and now you don't even know what's going on, and you're not supposed to be on YouTube, and you're not supposed to be on social media, you're not supposed to be in the on the news. And everything about this case is newsworthy. Man, shout out to the jury. I hope they are watching VHS tapes, reading a Bible, reading the Quran, reading something. Because if they turned on the TV, picked up their phone, we might be losing some jurors because this is hard to stay away from. Anyway, so they were supposed to share each other's demonstratives to one another so that objections could be made prior to the presentation of the opening statement, which is a very good look. Oh, they got a YouTube. All right, Ben still said, check out YouTube. Try me if you want to. This is a very good process because when opening statements are taking effect, you do not want to object. It looks bad when you're completely interrupting your opponent in their opening statement, has the propensity to look bad. And then there's sometimes that it's not allowed. So, but there are certain instances when it's very much allowed, when you are inserting evidence or making statements that are not evidentiary, provable, and or things that have been motion eliminates that have been passed that certain evidence won't come in, but yet you're speaking to them. So things like that can get objections sustained during opening statements, closing statements. Don't remember, go check the if you don't remember, then you would look at the Deputy Heard trial and remind yourselves of how objections can get sustained in opening and closing. Thank you. So anyway, back to this. On Friday, November 24th, 4:58 p.m. Oh, Lord. Lawyer Love shared her purported demonstrative aid via email. During opening statements, however, Lawyer Love showed a completely different, never before seen demonstrative aid, which was in clear violation of the court's order. And so then, thank you. He, Mr. Steele cites another YouTube viewing here, dated for November 27th. So basically, and the biggest problem with that is just in any evidence. If you're saying, this is the evidence I'm going to share, this is the evidence that I'm going to present, this is what I'm going to demonstrate, here's the demonstrative, and then you go to court and it's all different. You have robbed the other side of a fair trial just in that alone, because they can't respond, right? Oh, that was what's his name? I don't want to say Ben Affleck. That's not his name. Alec Baldwin. That was the Alec Baldwin case, right? There was evidence not turned over. Brady violation. You have to share the evidence. And so when we went through the ex parte, I had Brady violation concerns when it was this paragraph about, we keep talking about this yet and yet that, we keep saying yet, but truthfully, we don't know. It was like, I don't see anywhere it says yet. And then there's a statement where one of the 80s, whether it's Love or Hilton, says, I just don't know why you would want to admit to something you didn't do. And Copeland is quoted as saying, you don't know what I did. You don't know what I didn't do. You can't speak to what I did. It's like he makes some kind of response like, you don't know what is, if I did this or not. You can't say that. And then later on he says, I did these crimes. These are Brady violations, because now there's someone else who says, I'm the person who actually perpetrated the crimes that you're putting someone else on, that you're charging and indicting other people for. Then, like I said, my other issue was that the attorney Hilton was like, I don't care if you lie, you can lie on the stand, just don't tell a big lie. So we had all kind of issues. The court denied Mr. Williams' timely motion for mistrial, and there were no consequences because of Love's intent intentional misconduct, right? She intentionally gave one particular demonstrative and turned around and used something different and never updated still. What I want you guys to see also is that they have the footnote here. Footnotes are interesting. Don't skip all of them, but I may not get through all of them because I want to keep this as kind of short as possible. You probably heard a lot of it already. During voir dire, lawyer Love misrepresented the demeanor of veneer jurors to attempt to have the court excuse for cause potential jurors that lawyer Love did not want to serve on the qualified veneer panel. Oh, okay. The court did not admonish lawyer Love for these misrepresentations. Undersigned counsel does not have a transcript of voir dire and cannot locate YouTube video audio of trials voir dire on these points. Okay. And that was relative to the fact that, okay, so this motion is based on conduct of the court in relation to the prosecution and other aspects of the case. And so therefore this footnote says there's also this other instance, but I just can't show you and point to a transcript of it. So I can just tell it to you, but I just don't know. I don't have the backup, you know, when I told you guys before, P's and A's, you make a point, you put an authority with it. So every citation here, these are points, here are the authorities that's coming with it. This is not really a P's and A's outline, but that's just the basis of any good lawyer writing. You're going to say a thing, you're making a point with that thing, you have some factual basis to it, and then you show your authority as to why this is improper legal procedure or, you know, whatever. All right, so during the opening statement, lawyer Love defied another court order by introducing to the jury that undersigned counsel had represented other people charged in this case. Okay, specifically during her PowerPoint presentation, lawyer Love highlighted to the jury that undersigned counsel represented co-indictee Laylock. That's the pronunciation. Again, there were no consequences meted out by the court, meaning she could tell lies, blatantly misrepresent things, and she wasn't getting reprimanded. Now, here's a footnote for the YouTube links that were contained above. The video audio also included on a thumb drive, okay, so you can see that. He's letting them know, listen, you don't have to click here if you don't want to, because I have a whole thumb drive for you. Just in case the YouTubers decide to take it down, don't you worry. We have preserved the evidence and granted our own copy. All right, furthermore, the lawyer Love accused undersigned counsel of knowingly intentionally misrepresenting to the jury that witness Mr. Bean was taken to Grady Hospital by police directly from the scene of his arrest on September 11th. At a bench conference, aka sidebar, not in front of the jury. A bench conference is that which happens at the bench. Nothing, the jury's not around for it. Whether kicked out of the room or it's a sidebar in the room, they don't get to hear it. Lawyer Love falsely stated that she had evidence on her table to prove that undersigned counsel fabricated evidence as Mr. B never went to Grady Hospital on September 11, 2013. See YouTube. Okay, he has me so, okay, I gotta see it. Oh darn, is it gonna allow, are we going down a rabbit hole, people? Are we going down the rabbit hole? I don't know. I'm there. Still has gotten me there. I'm there. I've got to go. I've got to find out. Okay, so this is hard. We need to find the right time. 326. Okay. 326. Okay, shout out to Law and Crime. Okay, well, okay, bench trial 326. So obviously is the sound is off for us, Ben. What are we supposed to do now? 355 through 359. Okay, I don't know, because it's going to be muted to us as a public because it's a bench hearing.
City of Atlanta Police Department coming out and speaking with you.
My statement was, I don't remember that from 2013, sir.
Do you remember that while at Grady Hospital, this is before ever being taken to the Fulton County Jail, you spoke with that detective?
No, sir.
Do you remember the detective asking you questions about the incident involving the armed robbery of Mr. Dotson and almost killing the police officer Roberson L. and striking the other police officer's vehicle and careening over the embankment into the wall and fleeing? Do you remember that?
No, sir.
Do you remember telling that detective, specifically Detective Lewis, at that time, that there were 3 people in the Nissan red Altima vehicle?
No, sir.
Do you remember telling Detective?
Okay, well, that's that. I mean, to the extent, if it's going to be on the bench conference, we're not going to hear it, so it's going to be relative to the transcript. But anyway, lawyers' Love's allegations against undersigned counsel were proven beyond any doubt to be totally knowingly false. This is where we're saying that she had accused him of doing something unethical and being, or saying something that was wrong, and the judge counted it unprofessional because yet the court did not admonish Lawyer Love at all for falsely accusing another member of the bar of being untruthful. That is very much a major issue. When you're a member of the bar, you may not have the stature of the judge, but you too have the responsibility to the court. You're a member of the court, you're part of the court system, and you have a license. And that's what it means to be a member of the bar. There are a lot of individuals who have gone to law school, passed their college courses and receive what is called a JD, Juris Doctorate, but they do not practice. They're not an Esquire. They don't go for the license. Or they have a bar license elsewhere and they end up moving to a new state and they don't have a current license of the bar where they live and end up not practicing law anymore. They retire from law altogether. But nevertheless, when you are a member of the bar, being untruthful is an ethical violation, which can take your bar license away if so found to be accurate. So it's a big deal to call a lawyer a liar, right? And everyone says, oh, lawyers lie, they lie for their clients. No, they just find other ways to tell the truth. That's the art of being a lawyer. It's telling the truth in a different format, but it's not blatantly lying or giving falsehoods, and especially not misrepresenting the truth to the court. Those things are considered unethical and will get you disbarred under certain circumstances. So over Mr. Williams, which is the defendant's objection when the state was attempting to introduce January 26, 2015 social media postings from a co-indictee Garlington's account during the testimony of Detective Gaither, Lawyer Love told the court that only Mr. Williams' voice could be heard on this video, except for one other voice saying the words "yeah" in the background. Undersigned counsel told the court that Lawyer Love was incorrect and that several persons voices were audible on the social media posting, and Lawyer Love continued to falsely accuse undersigned counsel of misrepresenting facts to the court. Of course, Love was proven to be untruthful in her false allegations and wrongdoing against undersigned counsel, although it was objectively proven that Lawyer Love falsely accused another member of the bar of misconduct and lying to the court. The court did nothing to admonish the Lawyer Love. This pattern of permitting prosecutorial misconduct illustrates that the court wrongly favors Lawyer Love and the state of Georgia in this case. And that is the biggest issue here. It's a pattern of permitting the prosecution to have misinformation, false allegations, complete wrongdoing, several forms of untruth, and not being admonished. And consequently, it gives the impression that the court has a wrongful favor towards Love and the state of Georgia as a prosecution, not the state itself, but the prosecution is what this is representing. So June 6th in 2024, Lawyer Love falsely accused the undersigned counsel of purposefully extracting tampering with jail recordings of Mr. Copeland. This was another knowing malicious, false allegation by Lawyer Love. There's like, there's no honor amongst thieves, right? But even thieves and gangsters got a code. This prosecution team, I just want to know what won't they do? Like, give me that list, because there seems to be no end to what will be done to get the conviction. And that does not serve the public in the way that one thinks. Getting a conviction at all costs, without merit, without precaution, with Brady violations, with with a lack of camaraderie with your fellow attorneys, with holding evidence, with just, and I'm not saying all of these things necessarily apply here, but they sure do appear. They do appear to do so. And I've only looked at this case for maybe a week or two. But what this prosecution has done is it kills the veracity of the case. And it's hard when you're in the middle of it, because you're like, I gotta get it done. It's sweat, tears, it's everything. I think I talked about this before. Like you're hours and hours on end. You probably lost hair trying to be ready for trial, let alone be in trial. And then, making sure you produced everything and received everything and reviewed everything and understood everything and understand how you're going to present your case and what makes the most sense. It's so much that goes into trial. I respect it. I love it. It's my enjoyment. I enjoy it. However, when you go after a civilian and you don't Mirandize them, or you fail at some point to give them their legal right to counsel, or because they had that issue, they kept talking to a defendant who asked for an attorney, and they kept recording and kept going, like, and they got, and Glanville, Chief Judge Glanville did admonish them on that, and threw that evidence out. They weren't able to use it. But there are other things where when you are actually, this is the highest kind of things you can say that Steele has done as an attorney, that he tampered with evidence, jail recordings, that he extracted and tampered with jail recordings of Mr. Copeland. That's all the things that they are alleging against him as an individual put his bar license in jeopardy, puts his ability to feed his family in jeopardy. This is his livelihood that you put on the line, and he might go to jail if these things were true. But you do it cavalierly, and you're doing it with malice intent at some point, because you don't even verify. You just throw things in the air and just say a thing, and it's not true. You make the allegation, the court remained mute and failed to admonish Lawyer Love. That is a problem. I'm not going back to these YouTube pages because they're tempting. They're so tempting, but I might have to find myself listening way too long. So I just don't want to take up too much more time. On June 7th, Lawyer Love falsely accused counsel Copeland, which again is Mr. Steele, of accused counsel for Copeland. So Copeland was the witness. This counsel on June 7th is Melnick. So this is Melnick. He was still counsel on June 7th of Copeland. So on such time, Lawyer Love accuses him of violating his ethical duty to his client. Yes, she does. The court remains silent while Lawyer Love hurled more false allegations. I don't know if this is open court or not, but in that ex parte, I guess so, because they have a YouTube link to it, so it must have been open court. But in that ex parte, she goes into talking about Melnick's interest and feeling as though he did not have his client's best interest at heart. To me, it's more of a tactic against Melnick to get Copeland to have a better relationship with the prosecution than his own attorney. That's like that's tacky. Sorry, it's hot. It's hot in these streets. I gotta keep hydrated. You do the same thing. Okay, and then all the love in the world to those who are dealing with supreme heat and are in different states that have power outages. Praying for family of my own and through all of the community to be safe and to get through it. All right. In the jury's presence. Now, this is in the jury's presence on a separate occasion. The court wrongly accused undersigned counsel, Brian Steele, of being unprofessional as well as unprepared. Here it goes. Both allegations were completely false, yet the court's bias is so deep that the court refused to instruct the jury that the court's declaration was completely wrong on both occasions, as undersigned counsel was neither unprofessional nor unprepared. I want to see this one. I want to see this one. Okay, this is at 45. Okay, so we should be able to see this is 45 to 47. Wait, hold on. Wait, okay. Okay, wait, is it muted or not? Okay, hopefully, let's see. Can you hear? You should be able to hear. We're going to give them a thank you. I can't hear anything. Okay, because they hadn't started talking yet.
No offense, but
And of course, when I want them to talk, it's all at the wrong places. Okay, hold on. So 45.
I don't understand.
45 to 47.
Would you refer to it as a gang? If not, I couldn't hear you. The Super Bowl halftime show from 2022. I couldn't hear you.
Organization?
Okay. Would you believe that to be a gang?
Okay. So this is day 19. Good God, how long ago could that be, right? This is day 19. And let's go back to the motion to see. Okay, so January 22nd, 2024 was day 19 of the trial. We're gonna look at 45 minutes through 47 minutes and 30 seconds on this link, and then we'll see if we can. So we'll look at that from 45 to 47, just a little bit more, because I want to make sure that that's what we're encompassing. So let's see what happens.
If they're a crip.
They just say they're a member of a crip.
And is that a gang? Would you refer to it as a gang? If not, that's fine.
Organization gang? I don't know.
I couldn't hear you.
Organization?
Okay. Did you ever see the Super Bowl halftime show from 2022 with Snoop Dogg?
Yeah.
And tell ladies and gentlemen, jury, what you remember Snoop Dogg doing, or colors he was wearing, if you remember.
Blue?
Okay. And tell ladies and gentlemen, jury, whether you noticed that Snoop Dogg, well, who is Snoop Dogg? Tell ladies and gentlemen, jury, if you know.
Entertainer?
Well-known?
Well-known entertainer?
Performed at the Super Bowl?
Yes.
Along with other people?
Yes.
During that performance, did Snoop Dogg, did you notice, display a hand gesture similar to yours, showing a C or a crip gang sign?
Phil Snoop Dogg, 9 times 10 he did.
Okay. I'd like to show you, with the court's permission, Mr. Coco's permission, a video of that performance. Tell me if you recognize it, okay? Your Honor, is that okay?
Yes, sir.
And this will be marked as Mr. Williams' number 37, Your Honor. You have to show it to the state.
Have you seen it, State?
no.
Why don't you show it to the State before you show it to the witness?
Excuse me. I'm trying to look at the TV. I'm moving back up there.
Because he wants you close up in here, because when I sit back here, he doesn't.
When I thought I was gonna move back, I thought they were gonna play something right here. No.
He gonna bring the mic.
And you'll need to tell the court and the jurors and everybody, if you're showing just portions, what number it is.
Yeah.
Okay, thanks.
Is that an intern? Just quickly, like this span seems kind of a lag, but truthfully, this is not really that big of a deal in time. This is really what it takes. You have to clear with the opposing side. This is what I'm getting ready to show. Do you remember this in our, disclosures and discovery? And then You have to get identified with the witness, that yes, they know what this is what it is, and then they can actually publish it to the jury. So the process of evidence, getting evidence in is a process. So I need to
37. Thank you. Mr. Stevens, were you able to view what Mr. Kokomo showed you as Mr. Williams number 37?
Yes.
And is that an accurate depiction of what you described earlier of seeing the Super Bowl with a performer named Snoop Dogg?
Yes.
And was he making the references for the observations that you described to the jurors about the walk and the using the hand?
Yes.
And are there any, to your knowledge, deletions or additions or modifications, meaning were there any changes made to that, or is that how you remember it?
Yes, now I remember.
Okay, Your Honor, I move for the admission of Mr. Williams number 37.
Any objection to defendant Williams 37, madam?
No objection as to the video being played without sound and at the timestamps that Mr. Kokomo said that they would be played from Mr. Smith.
I'd like to play the sound and the entirety.
Have you seen the sound? Have you seen the entirety of it? Would you? All right. Why don't you just? How long is it? Just come on up here and let's play it. I mean, and screen it. This would have been nice for you to do before we got in here this morning, Mr. Steele. So please, in the future, don't do this to all of us, okay? Okay, sir, I'm talking to you.
Yes, sir.
Okay, this is not professional. Ladies and gentlemen, would you like to take a 5-minute recess?
Yes.
Okay, all right, why don't we do that?
a lot of hostility from the judge right there. But I do like that blue polka dot ensemble from Madam Hilton. Not that I like a lot of her lawyering tactics, but I like some of her clothes. That is the extent of it, I'm pretty sure.
Yeah.
That has to be it. Okay. So that was the beginning admonishment by the court. Let's find the other bait stamp. Okay, so okay. It's a whole nother link and a different date. Okay, Ben, you got me going. Okay, so we got 2 hours and 36 minutes. Trust and believe. I have no need or any endorsements of any advertisement. I am the commercial. So, great time to like, share, and subscribe. Okay. I appreciate those who have done so. Let's see, we're going to 2 hours, 36 minutes, and 51 seconds. 2 hours, 36 minutes. We'll just start here.
Following your direction. Mr. Steele, please don't try to engage in conversation. You're not prepared.
Hold on. Young Thug's attorney throws a tantrum after judge says he's unprepared. Law and crime, shame on you. Shame on you. First of all, I'm in the wrong account. How dare you? How dare you say such a thing? I'm gonna go back now. How dare you, law and crime, to say that it's a tantrum, a tantrum. First of all, zealous advocacy is not a tantrum. Secondly, when you say that the attorney isn't somehow unprofessional or unprepared, you know what you just said? You just said client, defendant, whoever you may be, plaintiff, you have hired the wrong one. So you have now effectively endorsed the other side, and you have demeaned them in front of their client into a place where it's like, don't pay my bills. Like, some attorneys get paid over $800 an hour. I know them. I know them. Over $800 an hour. Do you know Young Thug has spent millions on defense counsel? And the last thing you say to his attorney is he's unprepared because, and I'm sorry, Young Thug, Mr. Williams' mind, he's like, he's unprepared. He's unprofessional. What? Pay him $5 million, $10 million, $5 million he's paying him. I'm not paying him all this money if he's unprepared or unprofessional. That is so rude. And for any other, I'm gonna give you a thumbs up for making this available, but I do wish I could give you a thumbs like halfway down because the title right here is rude.
I don't remember
No
that.
better.
Would it be safe to say that any calls you would have heard would have had to happen before you listened to
Oh,
them?
yeah, absolutely.
So roughly between 9/11.
Absolutely. 236. Okay, absolutely too far back. Absolutely too far because I don't want to hear everything you have to say. Give me
They
two. Yeah. Here's another thing. I have not heard this judge once admonish the prosecution for not having enough copies for everybody. But under more circumstances than not in court, you would get yelled at for not having enough copies. The clerk needs a copy for record keeping, whether it's going to be the clerk or the stenographer. Everybody, they need a copy. The clerk definitely needs a copy. I would give them two, just one to have for their own self, so they can put their markings on. The other one so that they have the original version, so that they can upload to e-filing when needed, if needed. And then also the judge needs a copy because the judge wants to read along and be, you know, on the same page as you're questioning. The witness needs a copy because they need to be able to express the right, I don't know what that noise. Sorry, they need to express their recollection relative to the evidence set before them. And then all of the counsel, so all the attorneys need their copies so that they too can follow along. So to sit up, and this is not the first time I've seen this. I have not watched Day 46 before. So I know for a fact this is not the only time this has happened. But here we have Hilton showing one piece of paper to 1, 2, 3, 4 different attorneys. I'd be like, I can't see this. I'm too blind for this little bitty viewing. That annoys me. It absolutely annoys me that they do that. Is this Hilton? I don't know. Maybe this is not Hilton because she has braids, but maybe, I don't know. This trial went on for so long. She might change her hair 5 times. I wouldn't know. I think that's Hilton. But anyway, moving. Okay, here we are. 36. Who the other lady attorney was? Somebody's attorney. Let me see. Yeah, that's Hilton.
Everyone deserves the fastest, most reliable internet speeds, regardless of where they live. With Spectrum.
Everyone deserves to be left alone. We have enough surprises with the YSL case. We don't need more. Okay. It's a lot of just nothing.
Yes, sir. Probably do not. There was an objection, but the prosecutor trying to figure out which jail call can give more. She's only putting in additional 3. Tell us which ones they are.
Your Honor, I did identify 2 of the 3 that are the newer calls that have not been admitted. I identify one, and I'll call it, for the purposes of this, the chicken call, because it stands out because she's talking about cooking fried chicken. The second call after that is a call where she's at the baseball game, and that's very identifiable. It is the third call that I advise that I will ask the court if we can take a brief break so I can just identify which call that is so they can know. But I've identified that 2 of the 3 calls.
Do you have any objection to the baseball or chicken call? Absolutely. I know it's not just call. You have your visa yet? You have. Okay, well, why do I need more time? Because. Okay, you said, let you know, if the issue comes up. Okay, do you have any specific objections to those 2 calls, not the third one, that we're gonna need to take a break on, as I told you? I may have, I may not, but you're going to, you told me to let you know, so I will be. All right, following your direction.
trying to engage in a conversation. You're not prepared. Because if you prepared, you'd have told me, you invited this conversation. I did. I asked you if you were ready. If you were ready, you said, yes, Judge, I'm ready. After you do those two calls. Now, if you're not ready, then go ahead. Just tell me you're not ready, and we'll go ahead. I'll go ahead and we'll figure out something else to do. But if you have any other basis, then tell me.
You instructed me. I raised this already. You know exactly what I'm talking about. No, actually, go ahead. Then we need to ask the jurors why you think these are questions.
How long is this recording?
Crazy is this, that Brian Steele is saying, Your Honor, based upon what you instructed me, I need to review this and get back to you if I have an objection or not. And he's doing his like in a hint, like, remember you had said you told you remember that? So I gotta follow your direction. And he's like, so you're not prepared? You should just tell me you're not prepared. And this is happening in front of the jurors. And it takes the attorney to say, if I need to go through any further detail to reflect your Honor's recollection as to what you have ordered of me as counsel, we need to do that outside of the jury's presence. Therein lies where professionalism is definitely on one side versus another. Now, judges yell, judges, they have irate moments. That's not abnormal. That's not even almost newsworthy. But they typically don't do all of this hoopla in front of the jury. And here is an indication where it is done specifically in front of the jurors. And the one who had the good sense to say, this is not meant to be witnessed by the jurors, is defense counsel, which is okay enough to say if Judge Glanville had reasonable emotions in check, he would be like, okay, counselor, and then excuse the jurors and respect the fact that the counselor reminded him the jury is still in presence versus taking out all of his aggression and issues with it.
Right, and I would say for the third call, Your Honor, really as it relates to this particular incident, there's only...
And evidence being identified this way is weird to me. So in civil litigation, maybe this is the way y'all roll in criminal litigation, I don't know. But in civil litigation, we bait stamp evidence, we give exhibit numbers and letters to evidence. And so we don't call them chicken calls and what's the other one, some other thing that she said, like, these are very weird identifiers, okay? But I guess
relevant areas from
understands.
00 to 1 minute, and then 3 minutes and 50 seconds to 6:40 are the only relevant portions, I believe, for this particular matter.
Sorry, are you gonna want all of the third call to be played?
Listen up, you pump cheapskates. Since you seem to think our Air Moto was too pricey,
I tell you what, how long is the third call?
So all the calls, Mr. Steele is correct, all the calls are approximately 15 minutes, and the state does intend to play all 5 calls.
Your time, as much time as you want. I'm very fresh.
No, I'm talking about third call.
But I need to, the court instructed me, I don't know why we're doing this, the court instructed me to help the court. That's what I'm doing. When it comes up, that's what you instructed, so follow.
He said the court instructed me to help the court.
When you ask me to do.
Hold on, what?
When it comes up, that's what you instructed, so follow when you ask me to do. Now you're acting. That's what I'm doing. When it comes up, that's what you instructed, so follow when you ask me to do. Now you're acting like I'm not prepared. I'm very.
All right, I tell you what, will 20 minutes be sufficient for you to review your orders? All right, ladies and gentlemen, we're gonna take 20 minutes, and so after that, we'll come back and continue the executive RBC in 20 minutes. Okay?
All right,
All right, ladies and gentlemen, please be seated. Your technical seats, okay? Yes, sir.
Your Honor,
Do I need to listen to the call?
you don't, during this break. When we come back, we'll just want to know a decision about the transcript, because we do have a transcript for the first call. And that was the one we gave them yesterday, so just a decision
Well, I
about.
thought you were gonna take more time for that because
Oh,
they,
so they have not looked at it. Okay, never mind. Thank you, Your Honor.
all right, okay. We're in recess about 20 minutes.
I have a motion. I have a motion.
In regards to what, sir?
Your comments.
Oh, okay, what's your motion?
Yes, get him to a microphone. I cannot hear Ben. I hear him, but I don't hear him. Over here so we can see him.
Right.
This is the second time that this honorable court in front of the jury has addressed me inappropriately and wrongly. Second time. The first time I gave the state discovery of a song from a Super Bowl. Weeks before, there was an objection. You assumed that I didn't give it to the state. I didn't want to embarrass the court. So you were yelling at me.
Oh, God. Okay, doggies.
Saying, do you understand me? I didn't want to embarrass the court. So you were yelling at me and saying, do you
That was the first video we watched, so now he's addressing.
understand me? Do you understand me? And instead of saying, do you understand that you're wrong? I sat here and I said, yes, Your Honor. That was to protect the integrity of this courtroom and the court. Now you say in front of the jury how unprepared I am. I am not unprepared for anything.
Okay,
I have
Mr.
no.
Steele,
I need to make
Mr.
a
Steele,
record. Your Honor, I
Mr.
need
Steele,
to
wait a
make
second.
Wait a minute. I mean, dang, does Glanville ever let a person talk? I did find out that he served in armed forces, so I thank him for his service. And for our combat soldiers to come back to the U.S. and serve again in different capacities, and in his choice and his ascension, he is now a judge. It's highly admirable. However, I have no encounter with this man, so I cannot speak to any demeanor before now. What I see now is all I know, and this is got to be one of the rudest, most control-hungry judges I've ever witnessed. He is like, not, somebody say thirsty. It's not, it's like he is parched beyond, like he's been in the desert for 55 years and he needs water so bad that he cannot allow Brian Steele to make a record of anything. When we see the encounter is Brian is trying to get a record and he's like interrupting.
When you
Which gets him in trouble in the X party. We're gonna find out about that. That's when we found out he was a judicial mobster. I mean, that's just my opinion.
Keep delaying, okay? And that's what's happening to the court. You keep delaying and elongating and pushing out these particular, our ability to
Hold on. Pause for the cause. So Judge Glanville's irate behavior towards defense is because defense wants to defend itself. That is the right of the defense. Defendants have the rights. Now, yes, the judge is to keep things calendared, keep things in motion, but you have a prosecution that has 6 defendants on trial at the same time, 20 some odd coming down the pipe, whatever their numbers are, and they are accusing them of high crimes, RICO crimes. So the defense has the right to defend. This is what their right is. They have the right to full trial. They have the right to evidence. They have the right to evidence that includes things that could help them defend themselves. They have a right to know what is getting ready to be presented in opening statement as demonstratives, as well as the right to understand what particular evidence is being presented to the court and in trial. And so prosecution has the right to see what the defense is showing and have the right to rebut, but to turn around and say, you are delaying my trial by defending, by showing evidence, come now. There's got to be a better way.
to present a seamless case in front of the jury. That's
The defendants are having the problem with the seamless case. No, it's the prosecution doesn't have a case. How about that?
to
I'm sorry. The prosecution doesn't have a case because if the prosecution had a case, they wouldn't need to violate First Amendment rights to have lyrics played in a courtroom as a piece of evidence. Prosecution doesn't have a case. If the prosecution had a case, their star witness, Mr. Copeland, would not be duped into an immunity deal that prevents him from pleading the fifth, and in fact would have a witness that would want to actually testify, but they don't have that. If the prosecution had a case, they wouldn't need Your Honor to go into ex parte hearing to coerce and to influence the witness to testify against his desire, which he wants to plead the fifth by you double down, letting him know that there's 12 other defendants, and he has to either get up there and tell the truth on the stand, or has to go to jail until all of the defendants' cases have been resolved, and there's 12 more coming down after this 6. If the prosecution had a case, they wouldn't be relying on a witness who says, I've never told the truth. I just say in all days, I have always lied. I lied to my best advantage whenever it best suits me at all times. If the prosecution had a case, their star witness would not be saying, I lied to every last detective that I met with, so therefore I cannot recall anything that I said because it wasn't true the first time it was said, so I don't know what I said because it wasn't true and I don't remember the lies. If the prosecution had a case, then you wouldn't have an ex parte hearing where the witness, Mr. Copeland, would be sitting up there saying, I committed these crimes, who then therefore you allowed, Your Honor, to stay as a Brady violation because it was not turned over to the defense until weeks later when you decided to go ahead and release the transcript because the Georgia Supreme Court said, hey, yo, look here, big dog, trust me. You don't want the case to come to Supreme Court because right now we can tell. But since it hasn't gone through the proper process, we're going to send it back down to trial court for you guys to make a ruling. But if the appeal comes this way, we have different views than what was expressed by the court. And I said it before, trial courts do not make the law. The Supreme Court does. And the Supreme Court of Georgia gave him a nice, good hint. You cannot decide a motion that involves you. So that was a motion to recuse. So if the prosecution had a case, they would not need Your Honor to work so hard at keeping their case together and keeping their case from falling apart before the jurors' eyes. And if they had the case, whatever the defense threw at it, it would not be a problem. But you don't have a seamless presentation to the jury as to this case because the prosecution does not have the proper evidence.
Present a seamless case in front of the jury. That's my purview as a judge. And I've asked you a number of times, you and your colleagues on both sides, to go ahead and listen to whatever it is you need to do, prepare me as needed. Now, I asked you those 2 particular questions because if they turned over the audio to you in discovery and you've listened to them already, then you either have an objection or you don't have an objection. And I was trying to solicit from you whether or not we could just go ahead and just hear it. So you can imagine my frustration because all these little delays just elongate out our presentation in front of the jury. That's for your benefit, not for mine, Your Honor. So that's why I keep that.
That is the truth because Lord knows he get paid no matter what case he has to listen to. If it's your case or the next, he gonna get paid. He gonna get paid like I told you. All those other people gonna get paid, and it is to his benefit to get the case moving because he can move on to another case. But it's not to the defendant's benefit to rush a trial and not make sure that all the T's are crossed and all the I's are dotted. That is the benefit to the defendant. So at the peril and at the behest to the court, even you made attorneys stay on for 100 days when they begged you to let them off because their practices were going under because they couldn't afford to stay on because they weren't getting paid to be on a very elongated trial. You made them stay against their betterment, didn't benefit them, but it was for the benefit of the defendant. That's right. Constitution, the rights are to the benefit of the defendants. So yeah, maybe Brian still got better things to do than to keep sitting up here fighting this stupid case that the prosecution don't seem to have because they got to bribe everybody and then force people to lie on the stand. But as long as it's not a big whopper, it's okay to lie because they don't care. They'll just impeach them and move right along. You know what ethical violations that is, but it's got to be at least one, if not 2. Nevertheless, yeah, it benefits Ben still to get off this, Brian still to move along and go to the next client, but it doesn't benefit the client. It doesn't benefit the defendants to rush the trial. So it's up to him to sacrifice his own benefits so that he can zealously advocate for his client to ensure that all the T's are crossed and all the I's are dotted, and his client has the benefit of all of his constitutional rights.
That's why I've told you all at various times during this particular case, it's not because I want to embarrass you, Mr. Steele. It's just that I'm trying to kind of keep this thing presented in a way that the jury can listen to it.
And the court is wrong. What happened was,
The court is wrong. The court is wrong. First of all, trying to keep it where the jury can listen to it. It's not your job to make the case for the prosecution. It's like he gets a feeling like he has to help the prosecution formulate an understandable, digestible case. If they fail, they fail. You're not there to make sure that they do it right in terms of if the jury understands. Yes, there is such thing as called mistrial, because we don't know if you presented if you presented evidence and proved your case or not. We're not in agreement. Or not guilty because the prosecution did not make any sense. We had no idea what they were talking about. They didn't make sense. The evidence didn't show that. Their case was a mess. It is not up to the judge to make it clean for the jurors.
Finished, and I'm making this for the record. What happened is, and I don't get embarrassed by you, but I don't want to embarrass you. I made an objection that some of these jail calls have a third party who will not testify. I objected to hearsay. The state said it explains the effect.
Okay,
Which call? These calls, as you.
Okay, well then why weren't we taking them up beforehand?
The state just said just now.
Taking them up beforehand.
The state just said just now, these are the 3 additional calls that they want to introduce.
All right, well, then here's your response. I'm going to give you an acceptable response.
I'm going
Judge,
to make my motion. I need to make my motion.
Judge, there's more to this, and we need to listen to these calls.
Right.
Then I would have no, you didn't say that though. So I wouldn't have had that opportunity. But that's
It's time for me to get set up for therapy, and I use this room as my office. But the desk is.
I'm gonna need therapy. All these doggone commercials. Shut up.
telling you this, okay? I wouldn't have had that opportunity, but that's why I keep telling you this, okay? I mean, like I told you, forewarned judge, a happy judge. All right, so had you just told me up front, Judge, we have not had the opportunity to listen to all of those calls. We've only been able to listen to 2. I want to listen to the other ones. And
I've listened to the calls. I know it. I don't know what the third one they're trying to do.
Okay, well,
listen, let me just finish. So you presuppose I don't know what the calls are. Well, I don't know what the third call is because Ms. Hilton, who's professional, said, I'll take a break and I'll let you know what it is. But the other 2 calls are the baseball game and at a chicken. They're discussing chicken wings. Or chicken. I understand those calls. There's issues in those calls that you need to address. But I politely make an objection and say, Your Honor, based upon what you told me, which is what you told me, we'll take it up later. I wanted to raise it. You tell in front of the jury how unprepared I am. And let me tell you something. I am not unprepared. I don't appreciate the court telling me that. And you don't, and I asked you, tell the jurors that you were wrong when you admonished me last time. You said you wouldn't do that. This is the second time. And you know what it does to me? I don't care. I'm hurt because you're a court, but I really don't care. But what does it do to Mr. Williams?
Mr. Steele, I'm not trying to personally insult you or hurt your feelings, okay? You are a grown professional advocate. I'm a grown professional jurist. And people say things to me that border on the lines of I could take action or not. You have certainly said some of those things to me during the trial of this case. I have let them go. So, sir, that's just the trial. That's just the trial of the case, okay?
No, but that man's life is here.
And
Great point. Finally. So see, me in civil court, we're fighting over, is this contract enforceable? You said you were going to do a thing and you didn't do all of it. You still got to finish the others, or whatever you did was improper and it's cost us money, or, did the employee in fact have discriminatory encounters with personnel? Whatever, harassment, not whatever as in they're minuscule, but whatever in the sense that the result is usually a payout. It's a penalty. Like you get a penalty, listen, don't do that. You shouldn't have did that. Here's some money to the other side. And that can be like grotesque to some that, money is paid out versus especially those who have gone through criminal cases and they've lost the criminal case, but then in the civil case, they win money, just like with OJ or whatever have you. But the criminal sector is not a playground. I mean, court is a playground, but it's not a playground. It's an art form, right? Just depends on who you are in the courthouse. I mean, in the courtroom, but it's not a playground because people's lives are on the line. Now the corporation's your baby, you know, and you don't want to lose the baby. You don't want to have to sell it or, you know, dissolve the corporation because it's something you have worked hard on, but you live on. Your life is altered but not destroyed. If found convicted, these gentlemen have a high penalty because their life is on the line. They can be sentenced to whatever, but they have to. They could stay in jail. From what I read, they've been in jail for 2 years now. If they're convicted, they go to prison. So they're incapable of making money. They're not out in the real world. They're not playing with their kids. They're not in the music studio. They're not doing anything other than being locked up and then coming to court. Locked up, coming to court. Locked up, coming to court. Locked up, coming to, for over 100 days. Locked up, coming to court. Locked up, coming to court. Mr. Copeland, Little Woody, the star witness for the prosecution who just can prove that these people are a gang. He says, one, he did the crimes, and then two, he said, I'll say whatever it takes to keep me out of jail. Even he does not want to be in jail. This is not, oh, you're unprofessional. Oh, it's just that, like, words have power. This is where they are very powerful in court, extremely powerful in court, because when the judge gives an impression that something is nefarious, even if the jurors don't have an idea what the heck is going on, if they have the notion that the judge is constantly yelling at the defense, and they're like, oh, yes, prosecution. Oh, that makes sense, prosecution. Go right ahead, prosecution. You are giving a biased presentation to the jurors, and they're like, oh, the defense is all wrong. Oh, the defense is horrible. Oh, wow, the defense is unprepared and unprofessional. This is a problem.
And you know, you're doing a fine job in representing him.
Well,
But you know what? That's just.
I'm sorry. We could go down this rabbit hole all day long. I'm gonna leave this alone. Go watch it. There's like 15, 20 more minutes, according to Steele, as to where the judge refuses to admonish Attorney Love for her misrepresentations, or Hilton, or whomever at this point, but yet continues to admonish Steele and refuses to this is where he does the unprofessional one. So that's in these. So go check those out. That's the one we were just watching. And he refuses to apologize to him, or at least to strike the record in front of the jurors, so the jurors understand that that prejudicial, look, the court's over prejudicial and improper conduct towards Mr. Williams and his counsel, and its refusal, it's talking about the court's refusal to instruct the jury to disregard these impermissible and false allegations, as well as the court's failure to apologize for his baseless claims, proves bias for the state and prejudice against Mr. Williams and or his counsel. That's exactly what I was just saying. That was my whole rant and rave. Ben wrote it for Brian Steele. Mr. Steele wrote it for us. Lovely. Him and his team of paralegals wrote this lovely paragraph with my rant and raving 2 minutes ago. Moving on. Ooh. These above few examples raise reasonable questions concerning the court's partiality and bias against Mr. Steele and his counsel's efforts to attain a fair trial and fair tribunal. Okay, so goes into a lot of legalese, impartiality, problems that this, okay, here's another thing I just said. Mr. William languishes in jail without bond since his arrest, May 9th, 2022. That's 2 years and a couple months. 2 years and 2 months. And he's in jail because he's there without bond. So that means that they say he's a flight risk, so no. We can't trust that we'll be able to find him again, so no, he has to stay in jail without, so he can't bond himself out. No matter how much money the bond was, if he had the money to spend and to pay it, would not matter, because they say no, he's to be held without bond. They be in the court. Mr. Williams has been and is being denied his constitutional right to due process, fair tribunal, fair trial based upon prosecutorial misconduct and judicial misconduct. Okay. Judicial is the court. Okay, and the judicial process. Prosecutorial deals with the way the prosecution is operating, as the prosecution itself, as well as their process. Court exhibits patterns of bias over and over again. Okay, so this is here. Thank you, Brian Steele and Keith Adams for the lovely, which one is this? Let me make sure. Oh, they have an email motion eliminate. Thank you for the motion to recuse. I think this is the motion to eliminate. The order of the court probably deals with what is in this issue, because I think one of Steele's statements was you ordered us not to, you ordered me to review everything to make sure that it was in line with the motion to eliminate. And I'm telling you, you know, we need to get off from in front of the jury so I can let you know what my objections may be, because I need to review specifics on these pieces of evidence, which you would not do a motion to eliminate or certain pieces of evidence objections before the jury. You want to do it outside of the jury so that, you know, if it is in fact granted, then you would not have it before the jury and they don't have to disregard it. It's hard to unring a bell. And so one of the issues that Steele had was that the attorneys on the prosecution side was entering evidence with other persons on the evidence, other persons speaking. And there was a motion granted August 31st, whereby it was granted that this defendant's motion, which is Mr. Williams, motion to eliminate basically means motion to eliminate, to not present, to remove from the trial because it's improper evidence, probably concerned with hearsay, because it's number 2023, and it concerns the fact that other indicted persons in the case sought or actually retained attorney Brian Steele. So there was a motion eliminated that says you cannot speak to any concerns that the fact that other indicted persons in this case, they sought to, they looked to, or they actually did retain Brian Steele. This court already held a conflict hearing and denied the state's efforts to remove Steele as Mr. Williams' counsel. Therefore, the prosecution and all witnesses and parties are hereby ordered not to ever mention attorney Steele represented any other person in this indictment, unless and until same becomes relevant and is first addressed to the honorable court outside the presence of the jury. So there it is. The court ordered in November, based upon a hearing in August, this is in 2023, that there would be no mention of, there would be no evidence of, nothing to state that other defendants wanted attorney Steele to be their attorney. And it should never be mentioned. However, if for some reason those indictments were necessarily needed for the trial, it had to be relevant and it needed to be first addressed with the court outside of the presence of the jury. So here comes Hilton and crew trying to get something in, and Steele is like, wait a minute, we already have an order saying that this cannot get in. We need to talk about this. But he couldn't talk about it completely and openly in front of the jury because it's not supposed to be in the presence of the jury. Well, the court admonishes him in front of the presence of the jury, but he won't apologize. But you knew he could not defend himself. It was not a lack of preparation. It was, in fact, that the prosecution was trying to get around the motion to eliminate the order that was already in place. This includes any recorded calls. That means attorney Steele as a person sought to be hired by any of the accused. So that's what I think of that. Okay, anyway, let's get to a little closer in time as to what's going on right now. These are very close in time to what's going on, but it feels like 5 million miles away because, by golly, 3,000 things have happened. So all the motions to recuse were filed. That was, I think, 3 of them. They were trying to recuse Judge Glanville. They wanted to remove the prosecution, Hilton, and what's the girl's name? Love, because they feel like those 3 are now witnesses, because the ex parte had Brady communications. It had, communication, or at least at times when he says, I committed these crimes, it gave rise to the fact that we have a potential need to call other witnesses to determine what is it that Mr. Copeland said in the sacrosanct of the chamber that was not supposed to be an ex parte because there was no emergency. So, and he was a sworn witness. So that's another thing. Like, he's still a sworn witness after all these days. Copeland is still a sworn witness. I know he was on, I think, Attorney Bumpus's YouTube, or like making appearances. The reality is he's not supposed to be talking about the case. He's a sworn witness. He's not allowed to talk about it. So hopefully he's not talking about it. I don't know if he is or isn't. Okay, same people come up. This is now the 8th amended list, because after all of these people, guess what? He needs to add, where is he? Judge Glanville to the list. Will this allow me to highlight? Yes, highlight. So now Judge Glanville is on the list. What's Attorney Love's first name? She has to be on the list. Between her and Hilton, there's just no way. Okay, here you go. Simone Hilton is now on the list. And since it's in name order by last name, looking for Love. Oh, he didn't do Attorney Love? No way. Yeah, there she is. Madam Adrienne Love is on the list. So this is a list of witnesses. This is where this goes back to what I said some time ago. There are not meant to be any surprises in court. You don't just get surprise witnesses, because the next thing you get is the other side. You're on. It's not on our witness list. We do not know if this witness. We were not prepared for this witness. We have no way of knowing about this witness. And then you have all of the arguments. And that happened in Massachusetts versus Karen Reed, because those witnesses were FBI witnesses. And they were unknown to the defense. I mean, not FBI witnesses. There was a expert witness, Dr. Russell, who was not known to the defense and could not be put on the witness list because she wasn't known until, sometime during the trial, or right before the trial. I think it was like in the middle of the trial, actually, that she became known to the defense. So the moment she became known, that's when the defense gave over her credentials and information and requested to call her as a witness. And then the FBI witnesses were known, but I think they weren't able to prep those witnesses. So there was like this unknown element to what they got to say because the judge had ordered that they were not allowed to inquire with the FBI or get in the middle of the FBI investigation. So they put them on the stand, not unknowingly, because obviously if the FBI is looking into the candor of the evidence and the way the detectives handled the evidence, a defendant can kind of tell something must be awry, because the FBI is not just interviewing and investigating everything and everyone all the time. At least not anymore. Since Hoover left office, and even then he had a list. He had a list of people he wanted to investigate. All right, let's see. I want to get into first one we're going to get into here is kind of just like I said, I'm just trying to summarize what has happened over the last few days. Several different motions to recuse, motion for a fair trial. We just went over that. Just lots of motions, right? All the attorneys have been immensely busy. They've been busy writing motions to be heard, to advocate immensely for their clients. And then they also said, hey, we want to recuse Judge Glanville. We want to get rid of Love and Hilton because they are now witnesses. And then they said, okay, but guess what? I think this was Weinstein's motion. I can't remember whose motion, but it was like, and this was something I had agreed to when we were in ex parte, just for the appearance and just to show the general public that this is being taken up seriously. But anyway, the attorney Weinstein had put forth a motion to recuse Judge Krause. I think it was attorney Weinstein and Brian Steele, who both jointly put up a motion. As a response, the judge denied it. So here's the order for that. So here is the order denying motion to recuse Judge Krause from hearing the recusal motion. The basis for their motion was that the judge is of the same district. Chief Judge Glanville is a part of the district. He's chief judge. I know that people are saying, oh, that's just administrative. Yeah, but still you have to look that person and your coworker every day. And administrative means like, guess what? I'm going to give you an extra caseload because you're now my enemy now because you recused me from this case very publicly. So, you know, but she said, nah, bruh, I'm staying on. Keep me on. All right. So Judge Krause puts in the order. This case was randomly assigned. That's what he said. As long as that's even to what we read on the professional conduct for Georgia state law, their code, their statute requires that if you're dealing with a recusal motion, that if you don't already have a randomization to pick another judge, then you go outside of the circuit. But this court did have a randomization, and the Judge Glanville said she will be put, that this case will be put on a wheel, and wherever it lands, that's who's going to get assigned. So it's a randomization process. So this is why it's saying that it's randomly assigned, because it goes to the law of the land in Georgia that requires that if you don't have randomization, that you take it outside of that particular district and give it to a different judge. This case was randomly assigned to this court to consider certain motions to recuse Judge Glanville from further proceedings in this case. On July 8th, defendant Jeffrey Williams filed a supplement to motion to recuse Judge Glanville through title supplement. Though title supplement, a portion of the filing seeks to recuse this court from hearing the recusal motions. This court therefore must consider the portion of the supplement seeking this court's recusal before proceeding further. Basically saying, I can't look at the motions to recuse because I have to deal with this particular motion to recuse me, myself, Judge Krause. Interestingly enough, which then makes me say, well, how does she get to decide that? But never mind. Anyway, when a judge assigned to a case is presented with a recusal motion and an accompanying affidavit, the judge shall temporarily cease to act. Temporarily cease to act, meaning I can't look at the other case, the other motions, because you guys have put this motion against me. I have to stop acting on that upon the merits of the matter determined immediately. 1, whether the motion is timely. 2, whether the affidavit is legally sufficient. And 3, whether the affidavit sets forth facts that, if proved, would warrant the assigned judge's recusal from the case. If all of those 3 criteria are met, another judge shall be assigned to hear the motion to recuse. So basically, she has to decide that those 3 elements are met before she can recuse herself. So that was her basis. She cites US PR 25.3. Okay, on July 9th, defendant Williams filed an amendment supplement to remove an assertion of footnote. Others, yeah, because in that so that footnote, he files a further amendment just to remove footnote number 2. This is like a technical aspect, but that's because in that footnote, Brian Steele says in one part that Judge Glanville gave Judge Krause $2,000 towards her campaign, and then footnote number 2 is that Judge Krause gave X amount of dollars to Judge Glanville's campaign, and it turned out not to be true, that she had not given money to his campaign or of that amount or whatever reason. So he took that footnote out, and that's what that amendment is for, because it's one of the bases of saying you guys can't be deciding this case, these motions to recuse, because your connections are too tight. Whether it is 1, you guys are judges of the same circuit, or 2, because you guys are, supporting each other's judgeship and campaign thereof. In case you are unaware, judges have 2 ways of being on the bench. 1, they're appointed, the governor can appoint them, or 2, they can be on the bench because of being voted in, running a campaign just like any other politician. So if you remember your very long and full voter ballots, and they say judge seat 47 in district and whatever, those are different campaigns. When you select a name, you have voted them in. And so a lot of times we vote them in and we don't know who we're voting for, but I'm not going to get into that. I'm just going to get, that's the wrong one. Let's go back. I want to get to page 2 of this. At least I think it's page 2. This is a little difficult because it's not a PDF. Oh, wait, that's not the right page. Bear with me. Okay, let's see what's this one. Okay, so this one looks like it might be page 2. Let's see, or at least Colleagues in the court who have recused from the case. Only a 4-page document, so maybe that is. I think I'm missing page 2. I think that's the problem. Okay, let's see what this page 3 says then. Contributions or okay. So unexceptional campaign contributions are commonplace support during a judge's election. Oh, why am I doing this? I'm moving myself around. Sorry. During a judge's election campaign ordinarily are insufficient to require referring a recusal motion for reassignment to another judge. So she cites the court case Post versus whatever this is, state, Post v. State, 298, Georgia 241. And the probably pertinent decision is at 248 to 249. And so this is where it's stated that the allegations of exceptional campaign contributions are commonplace. Support during a judge's election campaign ordinarily are insufficient to require referring a recusal motion for reassignment to another judge. They're insufficient. So basically, ordinarily, that's not a big deal. The Code of Judicial Conduct reiterates this point, noting that when a campaign contribution is less than the maximum allowable contribution permitted by law, an affidavit, whatever, these people, an affidavit seeking recusal, must allege additional facts demonstrating the need for recusal. It's late, but it's really not that late. My mind is just out of there. An affidavit, of course, is the declaration. An affidavit is the document itself. An affiant is the person who is declaring it. So that I'm getting tongue-tied on it. So sorry. In summary, Rule 2.11A4 provides that if contributions made to a judicial candidate or to that candidate's campaign committee are permitted by law and do not exceed the maximum allowable contribution, then there is no mandatory requirement that the judge recuse. So she says, I don't have to. That's what she said. So no, I'm not recusing myself. So that's what she fell on. That's the sword that she fell on, that she was qualified to be the judge. It was a random choice. And, just because she was afforded a campaign support of Judge Glanville, based by law, she was not needing to be removed. So the court finds it is its duty. It has as much duty of a judge not to grant the motion to recuse when the motion is legally insufficient as it is to recuse when the motion is meritorious. So when it has merit. Words, powerful words. Okay, so this order is hereby denied. This supplement amendment motion is hereby denied. It is so ordered on the 9th day of July. So this is the Honorable Rachel Krause. So that was her order. She shall not recuse herself. So consequently, she's not recusing herself. So what did she do today? Today, the breaking news of it all, today, not any other day. Today, it happened just now. Today, oh my God. On the 10th, this was that, and the 9th, and then the 7th, and all the days, so many things have happened in this case. But today, not any other day, Judge Krause has given us what we all wanted to know, what was going to happen. She gave us an order. Well, not us. Let's be real. It's not us on trial, but we might feel like we're on trial, but we're not the real ones on trial. I must say it is a little difficult to find because I don't know where I put it. It's 10 pages. I just downloaded it, and I have crazy enough, I have the screenshot page, which is as much as what I just have right then, but those things are annoying to look at, as you can tell. As we just went through that one little small 4-page recusal, it was like, yeah, no, I don't want to do that no more. I don't want to look at that no more. No, thank you, no sir, no ma'am, because it's just annoying. So where did my okay, give me a second. I think I Oh, no, I didn't. Okay, let me do this. Let me look right here, 1 second. Okay, so here is the actual order that came down today, the 15th, July 15th. Today it's still July 15th where I am. Now you might be somewhere else and it's a different day, but on July 15th, Monday, as if we didn't have anything else to do, we find out that Judge Krause, she got lots to do. She got time today, okay? If you didn't know it, she got time today. And in her having time, we find out. So, Superior Court, this Superior Court is trial court. Superior Court of Fullerton County, state of Georgia. So state of Georgia, this is prosecution side versus these individuals here, the first 6 that I am aware of. And interestingly enough, as hard and as publicized as this case is to be considered against, Young Thug, aka or Jeffrey Williams, aka Young Thug, he's the second named defendant. So DeMonte Kendrick is the first. So I just find that to be interesting because they act like he's like the #1 head honcho, but he's named second. Anyway, Mr. Khalif Adams and all the rest. Okay, so in the case, here's now, this is a 10-page order. The other one was a 4-page order, 4 pages to say, no, I will not recuse myself. This 10-page order has some overall yays. It helps the defense, but there's some language that makes me say, yeah, you should have recused yourself. And I'm gonna show you what I mean. So overall, this is what it says. Order on motions to recuse Judge Glanville. This case is before the court to consider various motions to recuse, including defendant DeMonte Kendrick's motion to recuse Chief Judge Uriel Glanville, filed on June 12, 2024. This is docket number 247. Kayla Bumpus's motion to quash the show cause order and or to recuse Judge Glanville. This is Adams docket number 171. Because remember, Kayla Bumpus was the attorney for Copeland, the stand-in attorney for Copeland, if you will. So she typically does not have a direct interest in the case, but to a certain extent, she is interested in the case because she was in representation of the key witness. And Adams, who is this gentleman, Khalif Adams, is the filer of her particular motion, and this is docket 171. And then the third motion that was considered was defendant Jeffrey Williams' motion to disqualify or recuse Judge Glanville from all further dealings in the above referenced case and amended supplement. Okay, and Williams being Jeffrey Williams, it's his docket 587 and 611 with a footnote. The footnote number 1 is probably dealing with the amendments that we talked about just a second ago, but let's just double check. The court previously considered and denied defendant Kendrick's motion to disqualify Fulton County Superior Court judges from ruling on recusal motion, which was docket 260. And the portion of defendant Williams' amended supplement that sought this court's recusal, docket 612. So this deals with the one we just saw, the order that she put in saying that she will not recuse herself from, she being Judge Rachel Krause will not recuse herself from being the judge presiding over these particular motions to recuse Judge Glanville. I told you, it's a lot of recusals, okay? The specific facts necessary to determine these recusal motions are well documented in affidavits, court filings, certified transcripts, and video recordings available on YouTube. Listen, this is for all law tubers. This is for all legal beagles. This is for the paralegals, the secretaries, the managing partners, the what do you call them, the associates. Like, this is for the homies, y'all. It's like all of my legal homies. Take a minute, sit back and think. 5-10 years ago, would you ever in your life have a judge say the specific facts necessary to determine these motions are documented in video recordings that are available on YouTube. That is such a brand new concept. And for all of you millennials and Gen Zs, and like y'all are like, what are you talking about? We get everything off it. Yes, YouTube, TikTok, all the socials, it's all the things. Not in law. This is so brand new. It's just brand new. It's so brand new to see it black and white, to have a judge actually point to evidence being available on YouTube. That I have seen the day. I have seen the light. Okay, the tides are changing. Welcome to the new world of law. All right, having considered the record evidence, probably an applicable case law, the court finds this all. Okay. Now, findings of facts. So this is the court's findings of facts. Now, we talked in the past, who are the fact finders? Well, typically it's the jury, but when you only have the judge that's overseeing, they become finders of fact. So this is what this judge is doing. She has now have the findings of the facts. Here we go. These motions to recuse arise out of a multitude of multi-defendant prosecution brought by the Fulton County District Attorney's Office alleging gang activity and associated crimes. Oh gosh, will it let me? No. Will it let? No, because I didn't download it. I wanted to highlight that. Anyway, that's docket number 4. Although there were 28 defendants named in the indictment, only 6 were being tried as of June 7th, 2024. Okay, footnote number 2, Khalif Addison's case was severed. Okay, so he is not in the 6 per se, he's severed out. And though he is not currently on trial, his case was transferred to the court because Caleb Bumpus's motion to recuse Judge Glanville in association with the show cause and contempt issue was filed in Mr. Adams' portion of the docket. Oh, okay, so her filing being filed in his docket portion has now brought him back to bear, but he in fact is not on trial right now with them because his case is severed out. That's an interesting clerical thing. I don't know, maybe some of our court clerks can tell us why. Why, how, wherefore. Maybe that was the closest way to keep her from being associated with any other named defendant that is in fact a part of the trial. Put her motion with the docket for someone who was severed out, versus maybe just not, but why not put her under a non-party docket? I don't know. It's interesting. So if you haven't answered yet, let me know. Put in the comments, because we're not going to have a chat on this. So just put in the comments. Let me know. For all the court clerks, especially those in Georgia, like why is her motion a part of a severed out defendant versus a non-party motion? All right. The motions to recuse all arise from the same circumstances related to state's witness Kenneth Copeland. I think Brian still would argue against some of that statement, just because yes and no, they are speaking about the ex parte, but Brian still gets into a whole lot of, this is not just a new, this is total bias throughout. And we saw some of that in the other recusal where he's talking about things that happened in March and November and August and all of these other things where there's a presented bias by Judge Glanville towards the prosecution, even when found that whatever statement is being made against him as an attorney, unprofessional or unprepared, that he may backpedal that a little bit, but he won't apologize in front of the jury. So he presents a bias to the client and giving the jury the impression that Mr. Steele is unprofessional or unprepared. So yeah, most of the issues of the recusal motions are from the ex parte, but Mr. Steele also brings in sets of facts that go beyond the ex parte. So I don't necessarily know that they're all the same circumstances. Nevertheless, that's what she said. That's her finding. So on June 7th, the state intended to call Copeland to testify. Oh, we got another footnote. So certified transcript of June. Okay, docket 605. Okay. Prior to his testimony, counsel for Copeland, Melnick, appeared and indicated in open court that Mr. Copeland did not wish to testify and intended to invoke his Fifth Amendment privilege against self-incrimination. You know what's interesting about that statement? that makes me say, did you read the ex parte transcript? Because Copeland asserts that he told on several occasions prior to the date of the 7th that he was going to plead the 5th. And the Hilton replies, oh no, you didn't say that. And he goes, yes, I did, because you started talking about why would I want to do that? So clearly conversations about pleading the 5th were happening, but yet she would not admit to the fact that he was saying he was going to assert his 5th Amendment right. But here's the other thing that is absolutely absurd to me is that the night before, Attorney Melnick sent to Love, which is the infamous FU, which he says it was go F yourself, who cares? I mean, attorneys curse each other out all the time. I just think maybe the email portion, maybe not so much in email, but they definitely do it over the phone. Like the email thing, they kind of don't want it to get into somebody's emotion of evidence or anything. But when it comes over the phone, yeah, that happens. But so to pretend to be sensitive to it is a joke. It's a lie. Like it's all the audacity of her, grasping at her pearls that he told her to F herself. Yeah, that's not. She's not. There's no way she's a criminal attorney and she's spooked by someone saying that. But anyway, in that email, he starts off with, my client's pleading the 5th. He's not testifying. And she goes, well, who are you representing? Him or some other defendant? Why are you poorly representing your client is the implication. And that's when he goes, I'm representing my client and you are going to get him killed. And if you think otherwise, then go after yourself. That email, right? So there's more evidence to say that it was not just on the 7th of June that Melnick or any other person informed anybody that he was pleading the 5th. He had been doing so for some days prior, and even in writing, but whatever. I guess her element is she's reviewing the court record. So on the 7th, Melnick says he's pleading the 5th. Judge Glanville brought Mr. Copeland into court and discussed with him the effect of an immunity order Judge Glanville had entered that granted immunity to Mr. Copeland. Judge Glanville specifically advised Mr. Copeland that if he invoked the 5th Amendment and refused to testify, the state would ask for Copeland to be held in contempt and jailed. Judge Glanville has a thing about putting people in jail. Judge Glanville, like his contempts are like, it's like Halloween. He passes them things out like he's passing out Hershey bars. Like, hey, you're in contempt, you're over. Couldn't pass out enough bars compared to Judge Glanville putting somebody in contempt. But anyway, Judge Glanville also advised that if asked, Judge Glanville would jail Mr. Copeland for refusing to testify. Oh, okay. She's just saying the state could ask for it, and then Judge Glanville is saying he would grant it. Okay, but basically he's telling him the process of him going to jail twice. After that discussion, Mr. Copeland spoke to his attorney and then indicated he would testify. Okay, this is a finding of fact, but we got some facts missing. After that discussion. Oh, okay. He says, okay, then once called, Copeland pled the 5th. I was like, no, he pled the 5th. Okay, I got you. So the discussion was prior to him being sworn in. So once he was called, so being called means he's sworn in. So once called, that's when he became the sworn in witness. Mr. Copeland was asked to specify his age, and instead of answering, he stated, I plead the 5th. I don't know what's self-incriminating about your age unless you're in a situation against a minor. But anyway, that was his moment in time to start pleading the 5th. And pleading the 5th really is question to question. It's not just, I think you would say I refuse to testify because I, want to plead the 5th. And then, prosecution has to determine if in fact they're going to go ahead and go down this rabbit hole of you pleading the 5th every other question. And to some degree, they may just do that just to get the questions on the record, and you plead the 5th, make yourself look guilty, or like there's some cover up or something else going on, and they can use that, to help their story in the closing. So they might just call you all the same. In this instance, the prosecution needed Copeland so bad, they gave him indictment against all odds, and then did an ex parte and put extra pressure on him and a whole bunch of other stuff, put him in jail. They just was going to doing the most in the wrong direction. Anyway, Judge Glanville excused the jury and then advises Mr. Copeland in open court once again that he was in contempt and put him to jail until Monday the 10th. at which time Judge Glanville told Mr. Copeland they would revisit Mr. Copeland's willingness to testify. So he's on the stand because he was already called. He's a sworn witness. Now he's being jailed for contempt. And they were going to come back the next couple of days because this is on a Friday. So they're going to come back on Monday. And we're going to find out if you're still, holding it down for the cause. You plead the fifth still, or you're going to testify. This is what is supposed to happen on the 10th. Mr. Melnick spoke. Mr. Melnick, being his counsel, spoke to Mr. Copeland and then reiterated to the court that Mr. Copeland still intended to invoke his Fifth Amendment right if called as a witness. Judge Glanville indicated he would revisit the issue with Mr. Copeland on Monday at 8:30 a.m. and court was adjourned for the day. These set of facts, I think there's some insertion of some other elements as to why Ms. Kayla comes in, but maybe that will come in a little later. But remember, judges and attorneys too, especially judges, are like poignantly gonna speak. Their information is supposed to be to the point. So maybe this is why I say skip some of the other stuff about Melnick saying he's not available. Anyway, on June 10th at approximately 9:10 a.m., Judge Glanville met with counsel for the state, which is Adrian Love, and stand-in counsel for Mr. Copeland, Kayla Bumpus. And let's see, number 4, 2 investigators. Oh, this is interesting. So this is the footnote. So the 14 people that were involved are the footnote. This is why I say of some of her order is still protective of Judge Glanville's behavior, whereas I believe someone with less ties would, or a judge with less ties would be a little more admonishing and more abhorrent towards Judge Glanville's, misuse of power, like literally. But anyway, her footnote here is 2 investigators from the DA's office and multiple deputies were also present. There are more members of Judge Glanville's staff, including the court reporter who took down the conference. The certified transcript was filed into record on July 1st, 2024, Williams docket 598. Yeah. But was that timely? Because a part of this ex-parte meeting is the fact that the defense is supposed to be notified timely. And the information thereof was supposed to be given to them in a timely fashion. And we're almost a month later that the filing of the supposed full court transcript was filed on July 1st. Like 3 weeks later. Okay. And that's a footnote. Got it, Judge. The meeting took place in Granville's chambers. Counsel for the trial defendants did not participate in the meeting and were not aware that the meeting was taking place. Okay, they did not participate. They weren't aware, so they couldn't participate. The transcript reflects that Miss Love told Judge Glanville that she wanted the meeting to both impress upon, and that was my, I don't know who saw it, but when we reviewed the full transcript, that was my issue. The word that she says, Judge, I want you to impress upon Mr. Copeland. And I said, that is not a good word. Impress upon means it's a very legal way or respectable way to say, I want you to put pressure. And who puts pressure on witnesses or non-witnesses or the mobs? So impressing upon a witness, the judge cannot impress upon a witness. Like that was just, yeah, that was bad. So anyway, she wants both for him to impress upon Mr. Copeland the risk of refusing to testify and allow Mr. Copeland to ask questions before he testified. Ms. Love also expressed concerns to Judge Glanville about Mr. Copeland's representation. Oh my God. She did. That's the email. Ms. Bumpus, Ms. Love, and Judge Glanville also discussed the scope and effect of the state's grant of immunity to Mr. Copeland. I take issue with that. It's very, now, like I said, she's going to be more poignant to what happened versus me. I'm going to talk about all the details. That's what she's supposed to do. She's putting in an order. However, to distance Judge Glanville to put the defense attorney, the prosecution, and then Judge Glanville discuss the scope and effect of the state's grant of immunity is a vast misrepresentation. So please do review as we went word for word, because truthfully, It is Judge Glanville, Ms. Love, who are making all these representations on the immunity deal. And Ms. Bumpus is like, but he still could be at issue because he can't plead the fifth. Like he wants to, how long will this be? Like she's trying to get details that her client wants to know. It's clear, her client wants to know, how long are you gonna have him in jail for? He's willing to do 2 years, so what you got? Like, so before he gets in the room, this conversation is not just, oh, Ms. Bumpus, Ms. Love, and Judge Glanville are speaking onto the scope. This conversation is, they're explaining it to her because she wants to know for her client. This is before Copeland gets in, I think. Yeah, so Mr. Copeland was then brought to Judge Chambers when he spoke with and asked questions of Ms. Bumpus, Judge Glanville, and Simone Hill, Negro, child, girl, what? You know, there's an art to writing. There sure is an art to it. I mean, not just books. Clearly, look at this. Look at the artistry here. And for those of you who hung in with me and went through the whole transcript of the ex-parte hearing, you know this is so artful. This is like rewriting history. Mr. Copeland was then brought to the chambers where he spoke with and asked questions of Ms. Bumpus, Judge Glanville, and Simone Hilton, which is counsel for the state, who had joined the meeting. Okay. During that time, the state advised Mr. Copeland that he would remain in custody until the conclusion of trials of all defendants in the case, not just the 6 currently on trial. Agreed. Judge Glanville discussed Section 245507 for Mr. Copeland and his rights and responsibilities after a grant of immunity. We went over that too. That's also in the same video. Mr. Copeland spoke privately with his stand-in counsel, Ms. Bumpus, and then advised the court that he would testify. There's so many missing words. How do we have 10 pages if we're going to erase like 50 hours of history here? like, how do we have a 10-page document here, Your Honor? Like, literally, really, he talked to his attorney and advised the court that he would testify. It's not how that happened. He spoke to his attorney on a number of occasions. The court told him several occasions that he would be in jail for as long as whatever. He just has to get up there and tell the truth. There was, oh my God, there was so much more than just, okay, I'll testify. After the meeting and immediately before Mr. Copeland was brought out to testify, defendant Williams' lawyer, Brian Steele, advised the court that he was aware of an in-chambers meeting that morning. No, that's not true. After the meeting and immediately before Mr. Copeland was brought out to testify, Williams' lawyer, Steele, advised the court that he was aware. No. What Steele did was he said, the court said, okay, so Copeland's coming to testify. And it wasn't just after the meeting. This is why I say there's such a, there's like a wiping going on, some cleaning of facts. Like it's like a little cleanup here, right about here, because this is crazy. There wasn't that simple that that Mr. Copeland decided to testify just after speaking with his counsel. No, he was being constantly spoken with by the mostly the prosecution, but the judge also chimed in at times. There's times when, you know, things were being said in the judge's presence that should not have been said, and he didn't shut that down. Such as things like, well, if you can understand and admit to a murder, you know, if I don't have outside information about it, I can't try you for that. That was Hilton telling him, you know, basically get up there and lie or whatever you said you did, you got a full immunity deal. So you, as long as you give me what I need, all your other bad dealings are A-okay. That's the sum and substance of what that was about. That's not reflected here. And then it wasn't just after the meeting. This is actually an ex-parte here. Well, I guess this is just a meeting because there was no notice. I guess she's trying to be nice about it by not calling it an ex-parte hearing. She says after the meeting and immediately before Mr. Copeland was brought out to testify, Steele advised the court that he was aware of an in-chambers meeting. No. When they proceed into court at 11:35, 11:40, whatever time it was, so many hours after the court was supposed to be in session, judge says, okay, Mr. Copeland is going to testify. Brian Steele, attorney, inquires what happened. I thought we were going to hear from him to determine if he was going to testify. We've been here for a couple of hours waiting. What has happened during this time that he has so now changed his mind? And judge responds with, all I can tell you is that he spoke with his attorney and he now is willing to testify. In the most simplified way, much like they're simplifying it here. And And those YouTube videos that are official record according to this order are very explicit in that that's not what happened, because the ex parte transcript shows it wasn't just a conference with his attorney, it was a conference with the whole freaking prosecution and the judge and all of the, the essence of deputies walking around. So it wasn't so simple that he spoke to his attorney and now he's willing to testify. So Brian Steele was duped. Like, he was like, wait a minute, what, how, who, what? So no, that sentence is wrong. Mr. Steele, Judge Glanville, in which Glanville inquired how Mr. Mr. Steele objected to the ex parte meeting. This is, no, boo, no boo, and I don't mean the seafood. I'm not talking about sushi. No boo. You are missing like a paragraph, right? This right here should be a paragraph. Right. It won't even let me highlight. But right after morning and right before Mr., we got a paragraph missing. Missing right here. Copeland gets on the stand and starts testifying, Your Honor. He's on the stand testifying, and he says, I'm hot. I would like to take off my sweater. Can I take off my sweater? And the judge goes, sure, we'll take a 5-minute recess so you can take off your sweater. And I don't know, 45 minutes later, they come back. And when they come back, it's not, I don't think Copeland is out. The jury's not out. Everyone, I mean, not in the courtroom, they're out of the courtroom. That's when Mr. Steele Jackson says, it is brought, first of all, he puts on a motion to dismiss. This is what they actually started to call what he was doing. And he was calling it a motion to inquire, whatever. But anyway, he was inquiring with the court, like, wait a minute, hold up, tell me they ain't real. Like, and that's when the mollywop comes through, because Mr. Steele goes, excuse me, Your Honor, I need to understand, because we were told to be here for 9 o'clock hearing. We had to be here by 8:30. We didn't have a 9 o'clock hearing. We waited until about 11:30. When 11:30 came up, you just said, hey, we're going to have Copeland. Well, I found out in most recent affairs, and I have it on good authority, I believe this to be true. I'm not for certain if all of this is true, but it was told to me that there was this morning meeting that the defense was not included to, that it was you, the prosecution, and the witness, and there was some information that supposedly I was CC'd on that I didn't get an email, and it was an FU, and who told you? Who's the parent? Who's the mom? That, all that right there, that goes right here. That goes after morning and before Mr. Steele objected to an ex parte meeting. Because that right there was, he inquired to find out if there was an ex parte, at least have that sentence in there. And advised her that he was aware of in-chambers meeting that no. He said he had it on good authority and wanted to know, is it true? The judge, in essence, agrees that he identifies that was an ex parte meeting. The judge identifies it was an ex parte meeting. But okay, the art of writing. Mr. Steele objected to ex parte meeting, and a lengthy colloquy occurred between Mr. Steele and Judge Glanville. If that ain't the most artful way of saying Judge Glanville was totally berating Steele to identify his source of the ex parte meeting, a lengthy colloquy. Oh my gosh. Oh, okay. That was a very nice way to put it, Your Honor. This is where bias is shown to me, because the tomfoolery, the unprofessionalism from Judge Glanville is hidden in spaces that are not there, or is rewritten to state that Steele advises the court of some in-chambers meeting, and that Steele presents an objection to such a meeting, and that they have a lengthy colloquy. No, they had a showdown. They had a showdown, and judicial mobster Judge Glanville wanted to know who was the right. And you know why else you don't know what else was happening? Because every time Brian Steele tried to put something on the record, Judge Glanville cut him off. So there is no clear record. Yeah, lengthy colloquy. Yeah, it was a lot of back and forth. Yeah, that's cute. Judge Glanville inquired how Mr. Steele became aware of the in-chambers meeting. No, not just how he became aware of it, but how he knew of its contents. See, that's another thing that was most important to Glanville was, I don't need to know the sum and substance, but how do you know the sum and substance? Who told you? Because they very well may have, when he say, may have, he said when he was saying that Attorney Bumpus was going against attorney-client privilege, broken the privilege of her client. That was his excuse for wanting to know who the rat and the mole was. Because maybe Bumpus was the one, and if she was the one, then she needs to be disbarred because she broke client privilege, potentially. I think the client was like, hey, yo, let them know what happened, yo. The client was like, and she was like, I'm not getting involved. He was like, hey, they wilding out over here in the chambers. We was in the judge's office. He probably didn't even know what that was. He probably didn't even know it was judge's chamber. We were in the judge's office, man, and it was like all up on me. They was like pressing me, yo. Like, let's be real. He was telling everything else. Why do you think he has some alliance to you to keep? First, I don't even understand. What makes you think he gonna tell you the truth when he's been lying to everybody all the time? And why do you think he's gonna keep something from the other side when it's not, an cooperative witness? He don't want to be a witness. He wants to plead the fifth. He wants to get away from you. He wants to avoid you. All right. Mr. Still declined to reveal the source of his information, and Judge Glanville held him in contempt. Though Mr. Steele was allowed to remain in the courtroom on behalf of his client. Every sentence is like such artwork right here. This little phrase, oh, Mr. Steele was allowed to remain in the courtroom on behalf of his client, Defendant Williams. Was he? Because I could have sworn it took the prosecution to say, don't take him off to jail right now because we're getting ready to call Copeland back and he can't disappear. And then what happened to every other defense attorney who was like, I heard the same thing. Me too, me too. I said, it's so much missing from here, but whatever. Ultimately, Kenneth Copeland did testify on the 10th and was later released from custody. That's still money. Okay, so Tuesday the next day, Glanville issued a show cause order requiring everyone present at the ex-parte meeting to appear and show cause as to why they should not be held in contempt or disclosing information about the ex-parte meeting to defense counsel. An amended show cause order was later entered, setting July 1st for an in-camera review of the transcript of the ex-parte meeting. That's the one we went through, the July 1st ex-parte meeting. Hold on, you guys. Okay. The first motion to recuse filed by DeMonte Kendricks on June 12th. Mr. Kendrick's motion seeks to recuse Judge Glanville for his involvement in allegedly improper or coercive ex-parte meeting with the state. Okay, the June 14, Judge Glanville denied the motion. Really? It was 2 days later? It seemed like it was like almost instantly, but okay. On June 14, Judge Glanville denied the motion. Judge Glanville determined the recusal motion was timely, supported by an affidavit, and on a cursory review, contains assertions of fact to support the allegations of bias and partiality. Okay. However, Judge Glanville ultimately determined that because there was no way to verify the veracity of the information contained in the affidavit, and there was no actual evidence of the extent of the discussion during the in-chambers meeting, the affidavit was legally insufficient, and the motion to recuse did not require referral to another judge for consideration. Is that how he did it? This is the one where Weinstein was standing, and there's a whole lot of talking over each other. It's very confusing as to what the judge was going for. But so based on this judge, Judge Rachel, she feels that Glanville determined there was no way to verify. How could you not verify? There's a transcript. That's double talk, because Judge Glanville was tooting his horn about how there's a transcript. We have a transcript. We record ex parties for a reason, so that when it goes up on appeal, if there's any ex parte issue, you have it, and the appeal, and you can take it to the appeal process. And Brian Steele gets, that's the back and forth, lengthy, I can't even say the word anymore. the argument. I can't even speak anymore. I have turned into a blubbering idiot over this case. This is ridiculous. Okay. However, so he touted about it being recorded. It could go to appeals, but then that would mean he'd have to be found guilty, go to appeal, whatever. Because Weinstein said, "Well, you do a certification of expedite. Will you certify the expedition to the appeals court?" So they wouldn't have to wait for the case to be finalized, that the appeals court to rule on it right now while they're still in trial. He's like, no, because that stops the case. He's like, no, I don't think it does. I think that's the whole reason. And remember all that back and forth. So she's saying during this time frame, he found that there was no way to verify his Weinstein's affidavit or the veracity of the information contained in the affidavit because there was no actual evidence or of the extent of the discussion. I guess because he hadn't released the transcript yet, but he was the holder of the evidence. That's the problem. Anyway, June 14th, Bumpus then filed a motion to quash the show cause order and or recuse Judge Glanville from presiding over any contempt action against Ms. Bumpus resulting from an alleged disclosure of ex-party meeting. Yeah. And although referred to this court for consideration, Bumpus's motion to recuse is both premature and moot because Ms. Bumpus has not yet been held in contempt and because on July 1st, Judge Glanville canceled the show cause order. Actually, yeah. That's cute. That's a cute thing to say, isn't it? It wasn't premature because there was a show cause hearing ordered. You just said, what did she say? She said on June 14th, he denied the motion. When did he order the show cause hearing? The next day. So on June 11th, the next day, Judge Glanville issued a show cause hearing. So he put in an order. So how is her motion premature? Because she wasn't found in contempt? No, she had a motion to quash the show cause hearing order. Like, quash it. You don't have the right for a show cause. It's not premature at all. But it becomes mute because Judge Glanville took it off. He canceled it indefinitely, which was kind of cute because he was acting like he was doing somebody a favor when he was really just trying to backtrack his misdeeds. And she's doing him a favor by writing this so nice and saying things like Miss Bumpus was premature. Okay. On June 17th, defendant Williams filed his motion to recuse Glanville. It took you that long, Ben? Brian? I thought he was filing it day up. That's okay. It still was a good timely motion. So June 17th, Williams filed his motion to recuse. Divorced from its hyperbole. Yo, that's so disrespectful. This phrase right here is disrespectful to Brian Steele. It is reprimanding him when in fact he's actually 1,000% correct. And when I saw the ex-party transcript, you'll note that I say I have an issue. I don't know how far they're going to go because I believe they're going to try and use this email that Melnick sends over stating that you're putting a target on my client's back, you're making him a target or something to affect some kind of issue to make him to testify, that they were using that to be the emergency. But some other law tubers caught on to the fact that throughout the whole process that was documented, because I find that there are pieces that are missing, that's my opinion, but through the process, no one is, well, not no one. Hilton does get into a place where she's like, well, if there's something to do with your safety or if you're concerned about that, we don't know anything about that because you're not telling us. We don't know nothing about that. I mean, we just don't know anything about that. And Copeland never is noted in responding as in to say, I will be unsafe to get on the stand. So there is some inquiry into his potential safety, but the basis of the whole ex-party is to really make him testify. And that's a problem that it was done ex-party outside of the presence of the defense. That was Brady violations because there was information that he stated about his testimony that was taken from the defense, namely the infamous statement, I did these crimes. You don't know what I did and didn't do. I don't tell you everything. I've lied to you. I've always lied to you. I've never told the truth to you or anybody else ever. I've always lied. So he's given a whole bunch of statements that are very helpful to the defense that were Brady violations to occur at that time because there was no transcript and there was no information or notice of information to the defense. They had to find out. Someone had to be a mole. Someone had to parrot the information. All of those things that, be a rat, all those things that were being alluded to by the judicial system, which I'm now calling the judicial mob. And you come in and you say, divorced of the motions hyperbole. It's not hyperbole. And right now, it's making a mockery out of the court system in Fulton County. And it is truly going against Madam Fonnie Willis, because this is her county. So all of that perfect record stuff is looking like this is how you get it in a very imperfect way. That's what it makes it look like to the rest of the nation, because it's not a hyperbole. This is like a light being shone on misdeeds, and it reduces the weight of Steele's motion by saying so much hyperbole. So I have to parse that out. I have to divorce the hyperbole. Mr. Williams, which is Jeffrey Williams, motion and supplement also seek to recuse Judge Glanville because of his involvement in the ex-parte meeting, which Mr. Williams alleges also was improper and coercive. I thought we were finding something. Where's the word? Anyway, oh, okay. So she clears up some of her record because she had Kendrick being the first motion to recuse, with the very first motion to recuse come from Mr. Steele, but it was done orally and then sent to the Supreme Court. So she can't rule on it. It's not in her purview, so she can't take it up. Okay. Mr. Williams' motion alleges both actual bias and the appearance of bias because Judge Glanville allegedly participated in accusatory process when he met with Copeland, and Glanville became embroiled in a controversy when he held Mr. Williams' lawyer, Brian Steele, in contempt. Oh, so this is where she's glossing over the various instances of biases that he puts in his motion, which she divorces his motion of hyperbole, and somewhere up here she minimized it into I guess the lengthy discussion. I guess that's where she minimizes it. Okay, so whatever, kid. I'm slowly losing. I don't feel it. Even though the bottom line comes down to having some kind of win, this is why I say the words within the order are very like cleaning of the hands. I feel like hands are being cleaned because they were very dirty before this order. So, but I wonder if you could appeal a favorable order. So this might be cleaning of the hands for the public viewing, because if you didn't go through those hours and hours of information that we went through, and if you didn't have the gumption to deal with the strength and and the ability to deal with the hours of us going through the ex-parte word for word. I mean, I saw people just doing clips. I'm like, wait, that they talked about a little earlier. Wait, get down to where, I was like, oh no, you need to go word for word on this thing. But if you didn't do word for word like we did, like I did, then, whatever, you might can fall for this judge's rewrite of what happened. But anyway, so he, this is what he said. Okay. On July 1st, the day appointed for the parties to review a redacted transcript of the ex-parte meeting, Judge Glanville announced that he was releasing the entirety of the transcript of the ex-parte meeting. and was taking judicial notice of and making a record regarding certain matters associated with the ex-party meeting. There's no way, it wasn't redacted, that's for sure. There was no redaction. And so an attorney pointed out what redaction means. So you may not know, I should have said it then, I didn't say it, but redaction is where you remove information by putting a black mark on it. And then you put redacted statement for each line that you remove. Sometimes you just might be redacting a phone number, or you might have to redact a child's name, you know, things of that nature, or the social security number. Those are like small things, so it may not be like a full line. So in that small thing, you put the word redacted, and it lets you know that there's a little bit of portion here that is not visible. But even if it was a whole page, and I think we saw this in depth, we heard, there are only paragraphs of redactions. The redactions is like black lines, and then if it was a whole page, someone would put the word redacted. Like this page is redacted. When it's just a line or two, you put redacted for each line. If it's just a phrase, you put redacted for each phrase. This is the proper way. There are some lazy people that don't put the word redacted and they just do the redaction itself. What you're supposed to put the word redacted. So that, especially if it's a document, it lets the reader know that this is removed for a reason. And then if you are a party, you could inquire as to what is the reason, what is this information that is redacted, and you go into what it is. And just because something is redacted from the public doesn't mean that it's redacted from the party. So there's those instances in discovery where you can tell the person, oh, that's the phone number of so-and-so, that's the name of the child, the victim or whatever. And so they're like, oh, okay, got it. So they don't object to, you know, the fact of discovery being of issue and doing a motion to compel. So anyway, the ex-party transcript has nothing about reactions, nothing. There are a couple of times where there's small breaks. There's a couple of times where it is Bumpus will speak with her client. So there's, you know, no record of that. But there's nothing in there that says the word redacted. There's no redaction line. But there, if you read the transcript word for word, you can tell substance is missing. So where the substance came from, don't know, but it's not in the transcript. And is not privileged because it's not information that Copeland is speaking to Bumpus as the attorney and the client. It is something that Hilton keeps identifying when she says the word like yet. I don't know this, some, yet. There's no other reference to what she's talking about in that one paragraph. So that gives you a clear indication that there's communication that is being public to everyone else in the room, but yet it's being taken off the record for whatever reason. And the only reason that would be privilege. And you should have a notation, privileged conversation by and between XYZ from this minute to that minute. That's not there. Furthermore, there's the indication that, hey, you're having a privileged conversation, Ms. Bumpus, and the judge down there can hear you. So he's in the room. So not privileged, right? Anyway, she's in the room. Hilton is the one who tells Bumpus this, or Love, one of them. So, you know, if he can hear it down there and you're over here in my ear telling me what he can hear, you can hear me then, right? So what you're saying? Because she also gets into a point where she talks about, she overhears a privileged conversation with Copeland and Melnick sometime before. So she got an ear hustle in ear, okay, for stuff that is privileged. And then she's putting on the record in chambers in an ex-party hearing. Yeah, go for that word for word. It's a whole lot in there. Anyway, he announced that he would release the entirety of it. He made a lot of announcements. Most of what Glanville relied was a coalition of record of evidence about the recent circumstances of the case. Glanville also explained how he became aware of the state's request for ex-party. Did he? Okay. And addressing the circumstances of the contempt against Mr. Steele, Glanville explained the court's purpose and concern in pursuing information about the security and confidentiality of his chambers. I think it's improper for her to have that in there because she can't rule on the contempt hearing. That's before the Supreme Court. So now she's waving to the Supreme Court. The circumstances were for security and confidentiality of his chambers. Well, I wave back to the Supreme Court. She says that the YouTube recordings are evidence. Go to the YouTube recordings. He just wanted to know who told, who was the parent, who told, how dare they tell. Glanville advised that he had not instigated an investigation into surveillance footage, but had reviewed such footage for a timeline and security. Judge Glanville then explained his view that the ex-parte meeting was proper under Georgia law and outlined relevant law that supported his inherent authority to hold such a meeting. Here's another sense. This is another wave to the Supreme Court. Hey, Supreme Court, there's relevant law that supports his inherent authority. No, under emergency circumstances. Those exceptions, I don't know that you actually met them. And that's where, if they want to be nice, they could say that Melnick's letter email gave rise to an emergency circumstance. The problem is, I don't know if they're going to have a hearing where Ben Steele could argue in the transcript, Hilton expresses that they have no knowledge of some security issue. And there's nothing in this transcript that arises to any security issue of the witness. The witness does not proclaim any security issue. And the whole time the witness's concern was they did not want to testify, and they feel duped into an immunity deal, and they were also violating Brady versus Maryland because they did not disclose the information that was pertinent to the defense and able to defend itself, whereas Copeland admits to doing crimes that seemingly is indicted against those defendants, potentially. And he furthermore states that he's a habitual liar. So those are Brady violations that they kept out. So I don't know if they're going to have a hearing to where Steele can argue against it. But I got a whole bunch of nods to the Supreme Court by Judge Rachel here. She's very much, or this one, outlined relevant law to support his inherent authority. I don't think so. I think he had an abusive authority, but okay. Judge Glanville maintained that no one gained a tactical advantage as a result of the ex parte nature of the meeting. Yeah, okay. Judge Glanville also questioned defendant's right to be present at the ex parte meeting because the issue under discussion was between state and a witness who was represented by counsel. He questioned who? Judge Glanville also questioned defendant's right, meaning he disagreed that they had a right to be counsel. I mean, like, why are you being so artful? He denied defendant's right to be present. He didn't question anybody. He didn't go and ask judges, how do you feel about this? And furthermore, the meeting because the issue was discussion was between the state and a witness. No, it wasn't. It wasn't. The discussion was between the judge, the state, a sworn witness who was represented by counsel. This is when he says on the stand. He's on the stand. After making this record, Judge Glanville announced that the show cause hearing was canceled and that the recusal motions filed by Kendrick, Williams, and Bumpus were being referred for consideration by another judge in accordance with the Uniform Superior Court Rule 25.1 through 25.7. Sounds just like the same rules that Weinstein was absolutely hopping up and down about, I think on June 14th, when he said, you can't make that ruling. You have to follow 25.1 to 25.7. Sounds like that very same rule that he all of a sudden Judge Glanville, found out. And I guess because you want to keep it under 10 pages or you want to be, poignant, but this looks like you're trying to wipe the hands of Judge Glanville because there were so many instances where various attorneys, Adams, Weinstein, Steele, were all informing him that his actions were out of sorts. And you know who wasn't? Was the prosecution. And they have ethical responsibility. It's not about the win. The win is one thing, but the integrity of the court has to be maintained. All officers of the court are required to maintain the integrity of the court, regardless if they're on different sides of the bench. So just as Steele, Adams, and Weinstein were hyping and hopping and hooping and hollering about, motions to recuse and issues and ex parte meetings without them and Brady violations and potentials, and they need to understand what's going on and why. And all he wanted to know was who was the parent and all that. That's not none of your business. And Miss Love's rocking and a rolling and a hipping and a hopping and a whooping. All that was wrong on the prosecution's part. They know better. You cannot get a conviction at all costs because you lose integrity, you lose the authority of the court. So they also had the responsibility to say, Your Honor, we join in the defense motion for recusal because there's information at the ex parte hearing that the defense should have been a part of. Do you know why they won't do that? Because they were wrong. They were the ones doing most of the wrong at the ex parte hearing in the first place. Him being there and allowing present to it was definitely a problem. But there were other instances where I feel like some of his actions were coercive in nature. By just giving the impression to the defendant. And then also telling Ms. Bumpus, well, all you do is talk to your client and you tell your client to do this. And, you take these questions, you ask your client, does he have anything else that can be asked upon him that he feels would be inappropriate or might get him in trouble? And if so, just tell him, then he can plead the fifth, or he said, tell him to signal to you that he needs to talk to you and take a break, and we can just take a break. And then you can advise your client on whatever it is that may come up. So that's where Brian Steele said that the judge was giving legal advice to Bumpus. Judges can't do that either. Can't give out legal advice. You're not there to advise them how to win the case or to win their position. The judges are there to say what is legally allowed and what is legally unallowed. Calling balls and strips. You are not in a position to take a position. You are not there to teach the attorney how to be a better attorney. You're not the professor in the room. You're the judge. So no, Madam Judge, Honorable Judge Rachel, I don't agree with your washing of the evidence or restatement or flurrying and flowering the involvement of Judge Glanville. It's cute, interesting, but I don't find its accuracy. The motions to recuse were then assigned to this court for consideration. Here's legal framework. Motions to recuse are governed by a specific legal framework outlining Rule 25 of the Uniform Rules of Superior Court. Yep, 25.1 to 25.7 to be exact. A party seeking recusal must file a timely motion supported by an affidavit clearly stating the facts and reasons for the belief that bias or prejudice exists. The affidavit must be definite and specific and describe circumstances of extrajudicial conduct or statements which demonstrate, and remember, he was saying, I'm not doing anything extrajudicial. I'm not doing anything extrajudicial. This is why. It's because this is what is stated in the rules themselves. And when I say he, I mean Judge Glanville. This is when he was going on his soliloquy relative to why his ex parte was not a problem, which clearly was wrong, was demonstrate either bias in favor of an adverse party or prejudice towards the moving party in particular, or a systematic pattern of prejudicial conduct towards persons similarly situated to the moving party, which would influence the judge and impede or prevent impartiality in that action. That is based on 25.2. Bare conclusions and opinions are not legally sufficient to support the motion or warrant further readings. It means the same, it's like saying ditto when it comes to citations. It is the word for ditto. It's a legal thing. So that just means that's the same citation. Once such a motion is filed, it is the duty of the assigned judge to temporarily cease to act upon the merits of the matter and assess the timeliness and legal sufficiency of the affidavit and alleged facts. This is based on 25.3. If all three criteria are met, the three that we talked about in the very beginning, the motion is timely. That's one. Supported by an affidavit. That's two. And the facts alleged might warrant recusal. That's the third. Another judge shall be assigned to hear the motion to recuse. It, once again, based upon 25.3. When considering a motion to recuse, the assigned judge should be guided by Rule 25. Should be guided by Rule 2.11 of the revised Code of Judicial Conduct, which provides that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. So if he got bumped up into this ex parte meeting thinking that it was an emergency because there's something about the security of Copeland, when Love says, I need you to impress upon Copeland that he needs to testify, judge should have said, that's not what I'm here to do. I am a judge. I'm not here to impress anything upon witnesses. I don't make witnesses do a thing. So, sorry, 88 Love, I can't help you. Well, Your Honor, we're concerned of his security. And the reason why we are is because his attorney says that he is going to be somehow harmed if he testifies. Really now? What did his attorney say? His attorney says he's going to be harmed. Okay, well, we can talk to him about that. We'll bring him in and we will talk to him about his safety. His safety is a concern. That's the only thing we can talk about. Okay, Your Honor. Copeland, want to know about your testifying. Do you feel unsafe to testify? No, I don't want to testify. Okay, but you don't have any security concerns? No, I do not have any security concerns. Okay, in that regard, we now shall conclude today's proceeding, and we will now go back to the stand before the defendants to have our hearing that I called for 9 o'clock this morning. If that were the sum and substance of the ex parte, he probably wouldn't have any meat. Probably would not have any meat. Get it to the stand. Okay, so would like to let everyone know that there was an ex parte meeting earlier today with the witness, Mr. Copeland. Wanted to ensure that there were no concerns of any emergency of security. We are now going to find out of Mr. Copeland's willingness to testify. So bailiff, would you please bring out the witness? Mr. Copeland, you do know you're still under oath? Do you affirm? Yes. Ms. Hilton, state, you may proceed with your questioning. Mr. Copeland, on the night of the murder, were you there? Like, I plead the fifth, like whatever. If that folded that way, we wouldn't be here today. But it didn't fold that way because he allowed an ex parte hearing to come forth, probably told that it was an emergency because of security reasons, but the ex parte meeting gets all into a whole bunch of other stuff. And when it gets so far gone, he doesn't say, wait a minute, I need to disqualify myself from this proceeding because this is too much. You do realize there's information being said relative to his guilt or participation or not guilt or whatever, or his ability to be truthful. All of this is important to the defense and they need to be made aware of it. Nope, didn't happen. Okay. So the standard is objective from, you have to be objective. This is the standard for the judge to be objective from the perspective of a reasonable, fair-minded, and impartial person rather than affected judge or other interested parties. So this is going to this citation of this case, and don't ask me, somebody, this A&M Hospitals versus Alamashandi. That's my best pronunciation that I can do for that. All right, so that's that one. Standard is objective, okay? So that's what you're supposed to be, is objective. When you're calling and making decisions, you got to have no dog in the fight, okay? Okay, that's the point. If a motion to recuse satisfies the 3 threshold criteria, the assigned judge must refer the motion for reassignment and may not oppose the motion. That's the case. Look, this is Monday. This is the case that Brian Steele and Weinstein kept quoting, the Monday case. Please look at the Monday case. Please review the Monday case. This is the case that he talked about. The judge whose recusal is sought may not respond to the motion or attempt to refute the allegations which stand denied automatically, no matter how false or even defamatory the judge might know or perceive the allegations to be. Interesting. The judge may not do those things, but he definitely did those things when he made a whole announcement relative to the ex parte transcript and cited all of the reasons why that he was allowed to have an ex parte with a witness based upon those cases. Now, see, 4 paragraphs up, how she was saying, oh, he just made an announcement, but now she's quoting a case that says the judge whose recusal is sought, which would be Glanville, may not respond to the motion, cannot attempt to refute the allegations. He wasn't supposed to do all that. And that's based on Post versus State. A judge cannot become actively involved in presenting evidence or argument against a motion seeking his recusal without that defense itself becoming a basis for recusal. So once again, judge all that announcements according to, this is where I say her creative writing skills come into play. She called these things an announcement relative to the ex parte, where he goes into explaining why his ex parte was proper. Here is the case Post versus State that says judge should not respond to the motion, should not present evidence or argument case law and all of that, that's evidence argument. Okay. A judge has no interest in sitting on a particular case at most. His interest lies in protecting his own reputation. His efforts at defending himself against a motion to recuse will inevitably create an appearance of partiality. One reason is that if he defends himself, he becomes an adversary of the movement for recusal. Movement is the moving party. So that would be still, they're making the motion, so they're moving it. This adversarial posture may create an adverse which persists after the motion to recuse is denied. So you're not supposed to make a statement. You're not supposed to have these announcements. You're not supposed to make an argument. You're not supposed to quote these cases and law and codes of conduct and all the stuff that Judge Glanville did at the in-camera review of the ex-parte transcript. You're not supposed to do those things because it looks like you're defending your actions. And consequently, if the motion gets denied, it shows that you have an appearance of partiality versus saying, oh, okay, well, we'll let the other judge figure that out. Call me when you're ready. Let me know when the order drops. Instead of having that, he went all around the mulberry bush about why he was right. You can also see Richard E. Flam, judicial disqualification, recusal and disqualification of judges, section 15.7 at 435 2nd ED 2007. A judge who personally refutes a party's allegation for judicial bias may appear to a reasonable person to have exhibited a personal interest in the outcome of the litigation or to have aligned himself with the party resisting the judge's disqualification. And by attempting to refute a charge of bias, a judge may become or appear to have become an adversary of the party seeking his disqualification. Okay, we're finally gonna get to the meats and the potatoes of it. The reason why I go through page by page, I understand that other YouTubers and LawTubers, they clip things, and that's great because you get information instantly and your attention may be good for the quick. I go page by page, word for word as much as possible because the devil's in the details. There is like I said, we have washing of hands in my opinion. We have a lot of case law that does not agree with Judge in Post Free State, which is a 2015 case, does not agree. It also cites Isaac v. State, which was a 1987 case. They do not agree. A&M Hospital, the Georgia case, does not agree. Then we have recusal and disqualification of judges based on Richard E. Flam's section 15.7, does not agree that you get to go up and make an argument for why you have the right to have an ex-parte. He was way too emotionally involved, and I don't know that he's emotionally involved in the outcome of the case, but he was emotionally involved in the statements that Steele was trying to find, and he was emotionally involved in saying, I did this, my court, that's my chambers. What happens there happens there. It's not ex-parte is, I have ex-parte hearing with prosecution because they asked me to. Just like I have an ex-parte hearing with you when you asked me to. And Steele goes back and says, not with a witness. I wouldn't ask you to have an ex-parte hearing with a witness. And what do you do to the witness? You give the witness the feel that you have a partiality to a particular party. And in that case, prosecution, because they're the only ones there. And there's a whole lot of case law that says, nope, can't do that. All right. Now we're down to what she thinks. Here, Judge Glanville had previously announced on the record that the motions were timely and supported by an affidavit. In transferring the cases to another judge for consideration, Judge Glanville necessarily determined that the third criteria was satisfied, that recusal might be authorized if the facts alleged in the motion were assumed true. And they were assumed true. Most assuredly because Steele says, I'm told that there's a meeting. Was there a meeting today? You guys have a meeting? We were here for a hearing. Did you have a meeting that said something about da-da-da-da? He says, wait a minute, that was an ex-parte hearing? How do you know about that? That was a what? I didn't know this ex-parte hearing. Defense is supposed to have notice of ex-parte hearings. So yeah, he definitely identified and agreed to what was being said. Anyway. Therefore, Judge Glanville was required to refer the motion for reassignment and was prohibited from opposing the motion. Yep. Even though he kind of did that anyway. It is worth noting that this court agrees generally with Judge Glanville's assessment of the propriety of an ex-parte meeting. While the meeting could have, and perhaps should have, taken place in open court, nothing about the fact of the meeting or the substance discussed was inherently improper. And this sentence here is, to me, the biggest lie of this whole order, because what was inherently improper was the defense was never notified of the potential statements of the witness confessing to crimes, stating that he was a habitual liar. Those are pieces of information that the witness needs in order to cross-examine, that the defense needs in order to cross-examine that witness, to prepare for that witness. And any other witnesses that could say, hey, have you ever spoken with Copeland? Do you know him to be an honest person? You would start asking them those questions, right? Because you know that he has identified himself as a habitual liar. And you would want to know, does anybody else think he's a habitual liar as well? So it is important to your case. It helps you present your case. It helps you to prepare for witness cross-examination. You know, it helps you in your opening statement to be able to say, the prosecution is going to bring forth witnesses who are knowing liars. They have admitted to the same. And we're going to prove to you who one, in fact, has admitted on a number of occasions that their story changes over and over again because they are a liar on all accounts. And their word cannot be trusted. That's important. Jury needs to know. That's an important piece of information. To say that there was nothing improper, that information was not availed to the defense. Not only was it not availed to the defense until about 3 weeks later, it was not going to the defense because the judge said, you can take it up on appeal. These things are recorded. You'll have access to it during the appeal process. It took the defense to have a lengthy colloquy with the judge, which is actually a verbal battle back and forth, a zealous advocacy for over an hour with the judge to get him to even take note. It took the defense to spend hours for them and their secretaries and their paralegals and their associates to draft motions. Took them away from preparation of witness and examination and trial to draft motions of recusal, not one motion, 3 motions of recusals. So, and there was a tactical advantage given to the prosecution because before Copeland got out of that room, he said, I'm pleading the fifth. He stepped in saying, I'm pleading the fifth. He stepped out saying, I'm going to testify. That's a tactical advantage. Furthermore, the substance of the meeting discussed him getting on the stand and saying he wanted to admit to crimes and he wanted to lie. And Hilton saying, you know, if you don't remember what you said before, we will just impeach you on that. That's not a deal. You won't go to jail for that. So don't, you just remember, tell us what you remember and you'll be fine. And when Attorney Bumpus kept saying, but if you think he knows something, and if you think he's lying about what he knows, and he just says, I don't recall, you still will not prosecute him? I mean, as long as it's not a big whopper of a lie, no, we won't prosecute him. And Copeland says, well, I did these crimes. I'm telling you, I did them. So the substance of the discussions were inherently improper, Your Honor. This whitewashing is what we call this. It's when you go into something that's a lie or majorly disparaging and you pretty it up with words such as lengthy colloquy and substance discussed was not inherently improper. Nothing about that was an issue. That's called whitewashing. And I take major issue with this right here. And then the divorcing of hyperbole, the disparaging statement towards the defense, where if it wasn't for the defense making all of their efforts, banging their chest, banging, sounding multiple alarms, no one would know. If it wasn't for Zoom, no one would know. I mean, that's YouTube, no one would know. We'd all be sitting around going, oh, young thug is a thug and he is a gangster. Now we're looking going, wait a minute, who's the gangster? Who? The one with the dreads or the one with the robe? Who's the gangster? But you say, oh, nothing happened. However, in his order denying Kendrick's motion and in the process of making his record on July 1st, Judge Glanville added facts, provided context, questioned the veracity of allegations, and otherwise explained his decisions and actions and argued why those actions were proper, which goes against, and I hope she has the sense to say that, which goes against Post v. State and all of this other stuff saying, you don't do this. You're not supposed to do, you don't pose the motion, you don't make an argument. She's saying he did do that, in fact. While it may be appropriate for the judge to disclose information relevant to his potential recusal, such a disclosure must be made in a way that is as objective, dispassionate, and non-argumentative as possible, so the judge is not reasonably perceived as a hostile witness or advocate. Exactly, and trust me, these are quotations of the decision in Post. So she's just inserting someone else's words. I don't necessarily know that she believes them herself, just because of her artful declaration that there was nothing nefarious about the ex-party meeting. In presenting his record as to the recusal issues and in ruling on Kendrick's motion, is Kendrick his last name? Yeah, DeMonte Kendrick's motion, Judge Glanville. What does this say? Oh, we did that one. Judge Glanville evaluated and accepted the truth of his own factual allegations mandating his recusal. So his recusal is on a technicality that he tried to defend himself, versus his recusal should be on the fact that he had an improper meeting and allowed Brady violations to occur that he witnessed. This court has no doubt that Glanville can and would continue presiding fairly. So where is this court's impartiality, Judge? This court has no doubt that Judge Glanville can and would continue presiding fairly over this matter if the recusal motions were denied. But the necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville from further handling of this case. A judge who actively resists recusal may be fully capable of even-handedly presiding if the motion is denied. Okay. As we can see, even though we don't have the 3 dots here, we can see that a judge who actively is not the beginning of that sentence. Because what's interesting about Post, there is a issue with the appearance. Where did it say that? Yeah, so the judge whose recusal is sought, Glanville, may not respond to the motion or attempt to refute the allegations, which stand denied automatically, no matter how false or even defamatory the judge might know or perceive the allegations to be. A judge cannot become actively involved in presenting evidence or argument against a motion seeking his recusal without that defense itself becoming a basis for recusal. So I'm not sure this quotation that she has down here that says that exact same case is saying that a judge who is actively resisting recusal may be fully capable of even-handedly, which means, being even-handed, calling balls and strikes evenly on both sides, even though the motion is denied. I don't know. I feel like that's an artful clip, and I wonder what the rest of the sentence says. But so he is recused. Judge Glanville is recused on technical. on a technicality. So you're hearing all the YouTubers running around. He's recused. He's recused. We got him. Got him. He's recused. Everybody's on a party, right? Are they? But his recusal is almost like it was a gift. It was a gift. It was a graceful release. It even says something about excusing, weighs in favor of excusing Judge Glanville for further handling. You know what? You've been doing this enough. We're going to excuse you today. No, absolutely not. And it presents to me that, and this is me, so maybe you can tell me better, inform me better, but I feel like the only reason why he was quote unquote recused in the end was to save face for the public. That's part of her statement, and two, to prevent it from going on appeal to the Supreme Court. Because had she not recused him, then, you know, it would go up on appeal or Supreme Court. Because all of the selection and selective communication, selective findings of facts, and the omission of such major egregious behavior on Judge Glanville's part is kind of just, you know, just washed a little bit, watered down a little bit. And the only basis is given that because he proceeds to give a defense during the ex parte hearing, that is why he's being recused, not because of the nefarious acts of having the ex parte hearing. So victory, non-victory in my opinion, because Judge Glanville should actually be truly reprimanded for the actions, not because I don't like him as a person, I don't know him, but because the next judge who gets into office, and the next judge who has such a moment in time needs to learn, don't do that. They can't learn, don't do that, if you excuse it away and say, oh, the technicality is because he started to explain himself versus he was wrong in the first place. You have to teach the truth. You can't keep giving people outs and pretending as if, oh, that little thing wasn't the big problem. It's just a little problem. And so because of a little problem, we just want the public to have faith in the ruling. So we're just going to do for public confidence in the judicial system. Still unconfident, highly unconfident at this point now, because you're clearly covering for the judge. And this is why I say I really thought it should have been sent to a different circuit, because I don't care if Chief Judge has power over the other justices or not, the other judges or not. The Chief Judge Glanville has some type of camaraderie with his crew. But I mean, his colleagues. Even if you have different opposing diabolical views politically, you're going to have camaraderie with your colleague. And so this is what we get, as far as I'm concerned, a whitewashed, very creative rewrite of facts, and a cleaned up version of misdealings and disparaging constitutional, disparaging representations of licensed bar attorneys, as well as constitutional rights violations, as well as improper handling. There's nothing in here about the improper handling by the prosecution. There's not a thing in here about it. And I could have sworn it was in motion Steele, Brian Steele's motion, where he speaks. I mean, there's some biasy conversation, but there's nothing in there about the prosecution in nefariously calling the ex parte in the first place and not investigating the supposed emergency, which would have been the exception to having an ex parte with a sworn witness, is that it was an emergency for security and safety. They get down to that, like basically at the end of the ex parte, where it's like, well, we don't know anything about it, so, you know, tell us we know nothing. And he doesn't have any security concerns, but yet you still press him to move forward and testify, because you wanted to impress that upon him and have the judge's presence there so he can impress that upon him. And that's something that's very well stated by Love, ADA Love, in the very beginning. Judge wants you to impress upon the witness. Okay, anyway, so motion to recuse is granted. Motion to quash show cause is denied because it's mute. as the judge canceled the show cause hearing. Defendant Williams' motion to disqualify recuse Glanville from all further dealings in the above referenced case as amended and supplemented is granted. The clerk of the court shall reassign this case using the court's case reassignment procedures, which I think is randomization, but nonetheless, whatever. And that was the order of the court today by Honorable Rachel Krause of Fullerton County Superior Court, Atlanta Judicial Circuit. Yay, maybe, nay. I'm, I tell you, for me, to do something that's right by a defendant or a witness is the preservation of the case. Because if the defendant is guilty, I want the defendant found guilty without any appellable issue, right? I don't want to waste a dime on having to go to the appellate court because the judge had ex parte hearings or because the prosecution was pressing upon the witness to testify, or because Brady violations were happening, or because biases were being presented right before the jury that defense was somehow unprofessional. But when the prosecution is unprepared in some form or is improper in some form, it's, oh, okay, versus they are unprofessional. So I don't know what Jeffrey Williams and defendants have done or have not done. It's not my bag. I'm not in it. It's not my business. I understand that the charges are very severe, and I believe that the Georgia residents deserve to have a prosecution team, a prosecutorial team that is willing to prosecute criminals without trampling over their constitutional rights. Because there is a man dead. Someone did kill him. And whoever that someone is should be brought to justice. We may not ever find out because of all of the appellable issues of this particular case. That person may never be brought to justice, and that family may never have rest in knowing the truth, or that the individual or individuals involved get the full arm of the law by including criminal court because of misdealings. So it's not a matter of, do I want to set one person free, or do I believe or not believe in the facts of the case? How can I believe the facts of this case when the main author is a liar, self-acclaimed? But aside from just those particulars, my interest is that justice is served in the proper manner so that there's no way you can doubt that they are the one. No way. Like, get the right one, put them on the case, put a case against them properly with proper evidence, get a proper conviction, and by golly, let it stand up to every appeal that ever can be filed. But when we come down and you do it improper, and then they get away with it, if in fact they did it, you have yourself to blame. And you do the community a disservice. You do the family a disservice when you do things shortcut or improperly. So that's my soapbox. I'm getting off of it because I'm tired. That was a lot because there's a lot every day. But today was a good day for somebody. I mean, Judge Glanville can go back to doing other things, dealing with other cases, but he will not be dealing with this case. I don't see the win, actually, because the order is very light. There needs to be a slapping. There needs to be a tap tap. You ever have to argue with your parents or your grandparents when the baby gets to the kitchen? You tap tap tap. Oh, to it. And you sitting there thinking to yourself, if I was the baby, you whooped me on my tailbone, right? But now all of a sudden we don't tap the hands. No, don't believe that lie. It is for the benefit of the child. If they're in the kitchen and they get ready to touch the stove, no. That's hot. Don't touch that. Don't touch it. No. And it doesn't, I'm not saying beat up on the baby, but no. Something like that. That needs to happen to Judge Glanville. No, sir. No. And the Supreme Court did it a little earlier when they said, look, they was like, okay, so we got the docs, right? And we had read this, and thank you for this, but you didn't take this to the trial court. So you got to take this to the trial court before you can bring it up to us. But one thing we do know is this needs to be heard by a different judge. They was like, hey, Glanville, don't you rule on this motion. That was a tapping of the hand. That was a, no, sir, don't you do that. And ever since then, he done had some get right about him. He done been a little nicer, calmer in court, much more easier to speak with and to put things on the record, whether he disagreed or not. That's neither here nor there, but at least the record is a little cleaner now, a little subdued ever since the Supreme Court did. No. Dear sir, no. They did a little tippity tap tap. He his colleague, Judge Krause, she didn't tap. She didn't correct it. And the problem is all the other judges don't get to learn. They don't get to know that this is wrong. They don't get to understand, no. That ex party, no. And as a matter of fact, you know what, Brian Steele, just for kicks and giggles, go on and tell him to give you the full transcript hearing because you believe that the ex parte transcript is prejudicially omitted because it's supposed to be a full entirety when it looks like there are elements that are omitted from the transcript. Not redacted, but omitted. Redacted is a actual process that we talked about earlier. All right. So that's YSL. We don't have, oh yeah, we do have new judge, actually. The new judge, I wrote her name down. Oh, that's darn. I think her name is something like Shakira. Let's see if Google will be friendly. I'm kind of tired of Google. Not personally, it's just I'm sick of being on the computer. Okay, let's see. New ISL. Anybody want to talk about Glanville? Okay, yeah, Ingram. Her name is, Shakira Ingram. So she is the new judge. They keep calling it Fonnie Willis's RICO case. I think Fonnie cannot get a break at all. Let's see if I can get a judicial profile on her. Okay, so for our new judge, since Judge Glanville is no longer going to be presiding over the case, let's meet YSL Mr. DeMonte Kendrick, Jeffrey Williams, Young Thug, aka so forth, and all the others. New judge is Judge Shakira L. Ingram, and she is one of their senior judges, I believe, is what they told me. She's been with the Superior Court of Fullerton County since 2018. 10 years, so 6 years, I guess. And prior to that, she was a magistrate judge of Fullerton County. Okay, so she has, been over, about 9 years, looking at 9 years now of judicial history. Her education is a Juris Doctorate from Georgia State University College of Law. And she received her bachelor's at Clark Atlanta University. Lovely. And she has professional experience as a senior associate with Thomas Kennedy Sampson and Tompkins. Assistant DA at Fullerton County, Assistant Solicitor, Atlanta. Oh, she's would be, well, Georgia Association of Black Women Attorneys, okay. And women attorneys, all right. She's Delta, all right. Okay. Atlanta Board of Ethics. She has a lot of community service and past board member and current board memberships, and past chair of the Gate City Bar Foundation. And so she has, you can see what her orders have been for criminal cases. This is standing orders. Standing orders mean this is how you preside in my court. This is how you conduct in my court. Those are standing orders. Okay, so that pretty young lady. And I thought she's, it doesn't say it here, but I saw somewhere where it said senior judge. So I believe she's the senior judge within the Fullerton County. But it's surely she's been a judge for some time. And congratulations. She now has the case of a lifetime. The pain in the butt case. 100 years. And I think the other issue or thought process that one would consider is Georgia might want to change their rule. I think they have a rule where if a judge is recused, the next judge who comes in starts right where that judge left off. There's no preparatory hearing. It's like, I think she should have like a little trial hearing within the trial. Like, what are the current orders? Go through, what are the current motion to eliminate orders or the current? I mean, she has a lot of prep work before her to get ready for this trial because it's been 100 days. Like, it's a lot going on. It's not like a 5-day, 10-day trial. This is 100 days of trial. So there's a lot to be calling balls and stripes on when you don't know what motion eliminates have passed or not. So she has to go through a lot of the orders if she doesn't know already and get clarity. So furthermore, I wish her well, and hopefully she will be able to give some credence and restore some faith in the Fullerton County judicial system, because the public out here, these streets are talking, they all the way across the pond, and folks, it's like, what is wrong with y'all? So clear our name, please. Please help us, Judge Glanville. We beg of you. All right. Lyric Armstrong, your real estate agent and advocate, and see you in the next video. Stay out of trouble, y'all.